And you're live.
Good evening, ladies and gentlemen, near and far. You are welcome to this regularly scheduled meeting of the Planning Commission of the City of Annapolis. It is January 2nd and it's 7 p.m. And Ms. Consoli, could you please call the roll?
Yes, sir. Mr. Waldman,
Present?
Ms. Butler,
Present.
Mr. Riley,
Present.
Mr. Klein,
Present.
Mr. Cummings,
Present.
Mr. Bellamy,
Present.
and we are not expecting Mr. Svakianudis, sir. So we have 6 present.
We have a quorum and we're going to continue. The next step is the agenda. And there are a few things I would like to move to change. First of all, I think we need to add our deliberations on the findings and opinion of the Maritime Welcome Center in the Prince George's Park. So I'd like to add that to E and get that done earlier on in the meeting. I would also move the elections to the end. And I have a question about the agenda. On the drive was an annual report to the city clerk. Is that something we need to vote on? Kim, do you know?
Typically, the board would just vote whether or not to approve it or disapprove it with some comments,
Okay,
and then we'll send it on its way.
Okay, let's move that down to right before the elections, okay? And we'll do that right at the end. Is there any discussion about or questions about the changes to the agenda that I move? Do I have a second?
Second.
So moved.
Any discussion?
Nope.
All right, all in favor of those changes, please say aye.
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 All right, it passes. The next issue to get out of the way is the approval of minutes from November and December. Let's start off with November. Once again, all of this is on a shared drive, a Google Drive. So you've had the opportunity to see them. Nobody has proposed any changes. Do I hear a motion?
So moved. Or motion.
To approve?
Yes, please.
Do I hear a second?
Second.
Okay. Any discussion? This is November 7th. Okay, and no discussion? All in favor of approving those minutes, say aye.
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 I'm abstaining because I wasn't at the meeting.
Right, and as will Mr. Bellamy, of course. But December 5th, now there have been one change to the minutes having to do with the public access and clarifying that. We voted on. It's been incorporated into the minutes as they are provided to you. Do I hear a motion?
I move to approve as written.
Do we have a second?
Second.
All right, and all those who were there on December the 5th, please say aye.
Aye.
Aye. Okay. Mr. Bellamy, did we hear, you're muted.
Oh, I'm sorry. Aye.
All right, that they pass. The next thing I'd like to do is to move to the Welcome Center, the findings and opinion on the Welcome Center. There were some last minute changes. Only having to do with the critical areas section of the findings and opinion. You've all had plenty of time and plenty of reminders to read them and make any comments that you wanted to. The only change in that critical areas is frankly, I drafted it and I made a mistake. I was under the understanding that city rules on critical areas stuff was, I don't know, more stringent than the state standards, but that may have been wrong. And Mr. Jakubiak edited it, straightened it out, clarified it. And that's what we have.
I've accepted those changes in the document, so should be.
Okay,
Okay.
now, are there any motions in reference to our opinion?
I would move to approve these findings as written.
I would second that.
Is there any discussion? Let me ask a question. There was some discussion about adding a condition about uses and limiting uses.
Alex, that was yours.
That was mine, and I'm detecting not a great appetite for discussing that, so I'm just going to let it lay,
Okay.
just to not take up any more time on something that's not likely to pass.
It's perfectly your decision and your choice. There's a motion on the floor. There's a second to approve those findings. So all of you who were at the December 5th meeting, if you move to approve the findings and opinion and send it along, it's a final judgment because it was an application. And so it can be appealed. It's not a recommendation. It's a final judgment, okay? All in favor of approving the findings and opinion as written, say aye.
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 No, Stephen, you weren't there, were you?
No, I don't know if I need to not vote on that because I wasn't
No,
there, but
no, you
I
had to-
certainly understand the issue.
Yeah, you had to have been there. I know, we've seen it many times. Any nays? Hearing no nays, it passes 4-0.
I do want to thank Alex for writing that up. That's a complicated issue, and I think it's an excellent document. The fact that I wasn't there and the fact that I could read through it and I had very limited input fills me with confidence. So thanks.
Agreed. Agreed. Excellent.
Second, third.
Well, thank you, Mr. Klein. That was good. It's good work.
Pleasure.
All right, so that's important. That's moved along. And now we need to, our major issue of business tonight is ordinance 03324, which changes the appeals processes from the Board of Appeals, the Historic Preservation Commission, and the Planning Commission. So I would like to turn it over to Mr. Jakubiec to sort of introduce this and begin to answer questions.
Okay. Again, good evening, everybody. The proposed legislation would clarify parts of the zoning ordinance dealing with appeals and appeal processes. And I want to make it clear that there are kind of two parts to this legislation. The first part deals with stays of project work or proceedings related to appeals of decisions made by the Planning Commission or Board of Appeals or Historic Preservation Commission. So when those bodies make decisions and those decisions are appealed, they can be stayed now. And the reason they could be stayed or stopped is that there's nothing in our ordinances that discuss the staying authority with respect to these types of decisions. The work related to completing a development, once you approve it, is effectively stopped when it's appealed to the circuit court, or when the Historic Preservation Commission makes a decision and its decision is appealed. The applicant does not go forward with implementation of the project, and the staff, we don't do any further processing or permits because the matter is stayed It stopped until the circuit court handles things. Now, that's my understanding of how things go, but there's nothing in the code that says things should be stayed when things are applied to or when appeals are made to circuit court. What this language in the legislation does is to say that essentially things are not automatically stayed. They're stayed when the court orders a stay, or when the state General Assembly and the governor pass a law that stipulates certain things should be stayed. So there's a clarification that is being brought to bear. So throughout the decision-making authority by the Planning Commission, Historic Preservation Commission, and the Board of Appeals, it's only their decisions. There's not an automatic stay. And so this ordinance makes it clear that stays are not automatic. That's the first part of this legislation. The second part deals directly with our Board of Appeals. Now, the Board of Appeals hears appeals of decisions that are made by the planning director. So when I approve a minor development plan, like a house plan, that could be appealed to the Board of Appeals. And in that case, there is an automatic stay. And there is an automatic stay because state law is clear about it. There's no doubt, it's unambiguous. The land use article of the annotated code, state law, says matters before the Board of Appeals shall be stayed until resolved by the Board of Appeals. So that authority exists already. And so the zoning ordinance, our zoning code, Title 21, reflects that state law. So when an appeal is brought of the planning director's decision, there's an automatic stay. There's no question about that. And this bill doesn't change that, leaves it in place. What this bill does do with respect to the Board of Appeals is shorten the time it takes to get to a decision-making hearing. Right now, there is no limit on how long an appeal can sit before the Board of Appeals hears it. So the proposed legislation says within 45 days of an appeal being filed, the board will conduct a hearing. They'll open up their hearing and begin getting facts on the table and making decisions. The legislation also says that parties to an appeal shall be held or shall be heard in person. So if you're being appealed, for instance, if I'm being appealed as the planning director, I have a right to stand before the Board of Appeals and present a defense verbally, not just in legal briefs. The way that when the process goes with legal briefs being written by attorneys, then rebuttals being written by attorneys, it takes a considerable amount of time. And of course, it imposes a burden on the law office and my office in terms of writing and responding to appeals and procedural matters. But it places a bigger burden on the average citizen who is seeking to appeal something, or who is the applicant and whose project is being held up during an appeal of the director's decision. So the thrust of these changes with respect to the Board of Appeals is to make it easier for someone to present themselves pro se or without an attorney, to be more engaged directly with the Board of Appeals, to present their case and to get a decision in a quicker time, or at least get in front of the Board of Appeals so the board has the opportunity to make a decision. And this is born out of actual experience recently here with my experience with the city, where some appeals have taken considerable amount of time. One going through the cycle now was filed in July of 2024, and it's not scheduled to be heard until March. And that has impose a substantial burden on the applicant whose project is, effectively stayed, as you can imagine. And it has meant that there's been a lot of back and forth from the attorneys seeking advantage in the various proceedings, which has caused a lot of time being spent on procedural matters rather than getting to the heart of the decision and allowing the parties at issue to present their case in front of the decision makers. So we hope that these changes will make that process easier for the average citizen. So there's two parts of this. One of the sort of the circuit court stays, kind of state law, and how we clarify what happens within our planning and zoning function, and the other is with respect to the Board of Appeals and getting to decision making quicker. And Mr. Chairman, I actually would like to hear from Jessica. I know she's here as a technical resource from the Office of Law, but this was drafted first by the Office of Law, and Jessica knows these procedures at a level that's different from mine and could offer a different perspective, I'm sure.
Before we move to her,
Yeah.
I forgot to say something, and I apologize, but Ms. Butler, I'm going to ask you to do the findings on this and the recommendation on this legislation. Okay.
Sure, thank you.
All right, Ms. Corres, how do we pronounce your name?
You're saying it correct, Corres.
Corres, okay.
Yes.
All right.
So Chris did a great job of explaining the legislation and kind of where it came from. Just kind of as oversight when it comes from the Office of Law, it makes things a little bit easier with this legislation in that, the person that's appealing will have to file something in court to get the actual stay to happen, instead of it kind of be, it was automatic, but the language is very unclear and no one really knew what it encompassed, what it meant, what it stopped, what it included. So this is just kind of clarifying all of that by proactively making the person that's appealing file an appeal, which they're allowed to do under the Maryland rules in the petition for judicial review. They're allowed to file motions to stay. So that's something that they have the ability to do. And as for what Chris was talking about, the Board of Appeals, I think he did a good job of explaining it. It's been a long process. So the hope is to kind of tidy that up a little bit and kind of get to a resolution faster and make it more friendly for people to be able to represent themselves and not need legal counsel to be able to get to a resolution sooner, quicker, and hopefully just streamline the whole process and make sure the resources of the city and the person that's waiting for, the opinion to come out are more streamlined and more timely. So if there's any specific questions, I'm happy to answer those.
I have one quick one. Chris has done an amazing job since he's been here about trying to simplify and have some continuity and consistency with our zoning code. And this is an example of moving in that direction. But I'm wondering why we left out some of the other quasi-judicial boards and commissions that have a similar type of function, which is quasi-judicial, which they can be appealed to the circuit court. I guess my question is, wouldn't it make sense to include it all here to make it simplified and consistent?
I think, and I'd have to talk to Cynthia because she did the drafting of the actual legislation, but it's my understanding that in each part of the code, that automatic stay language is not the same. And so it was drafted this way to correct those areas of the code that address that. So I believe that's why it was kind of taken a little bit looking piecemeal, because she went through the actual code and pulled from the sections that had that automatic stay provision, because it's not under every board and commission.
So, but, okay, yeah, it's, I think it's under the port wardens, and I'm pretty sure, well, anyway, I was just wondering, because it seemed like a good opportunity to combine everything and make it simplified, especially with respect to some of the costs and issues that happen during the appeal process, the internal appeal process between, the Board of Appeals or a decision made at one of these other levels. So those other boards and commissions would have to undergo a similar review, and similar language may come up in another ordinance. You just weren't going to do it here.
Yeah, we were focused really just on the planning and zoning, like Port Wardens is handled by someone else in our office. And so they might have a different process and it might be a little bit more streamlined. But that is something that we can take back and circulate if that is something. I think you guys are going to be drafting something. You can send that back to us and we can kind of verify with some of the other departments if they have these issues to streamline it all.
Okay, that's great. Thanks.
Would any changes to appeals processes after the court warden decisions or the building board of appeals or the liquor commission decisions, would any legislation come before us for review?
I don't know. Like we were going to change the process for those commissions, for those boards, you mean?
Technically, it would not have to. Only Title 21 changes and Title 20 changes are required by code to go to the Planning Commission, Mr. Chairman. So it would be up to the referring body, up to the City Council to send it to the Planning Commission or not for those bodies, because they're codified under a separate part of the city code.
Right.
Yeah, and I noticed that the planning or Board of Appeals isn't on the list to review this legislation. And I'm wondering, number one, will the Board of Appeals be given an opportunity to review this legislation and comment?
Yes, they have been given an opportunity, and they will be taking it up, I believe, next week at their meeting.
Yeah, I think it's on there.
Will we be able to, I'm sorry, and will we be able to get their comments before we vote on this piece of legislation? Because it really impacts them, and we kind of would respect what they have to say on it.
Well, it seems like that's a procedural matter for the chairman and commission. You have 60 days to provide a recommendation to the mayor and city council.
You feel any time pressure to get this done?
Sure. I mean, when the city council refers something to the commission, we always feel time pressure to get it in front of you as soon as possible so you have time to make a decision. And we certainly want to get a decision to them within 60 days.
Yeah, I think the Board of Appeals, the Board of Appeals has already written up something, and they'll discuss it, as was mentioned, at their meeting on the 7th next week. And so you'd be able to glean something from that at that time, by the time of their meeting. I think it'll be available, what's in writing after the board goes, after the commissioners consider, and they've already been emailing around what's in writing. So once they all get on board with that, I think there'll be something available next week, Diane.
Will we be able to look at it outside the public view? Like, we won't get it in a meeting, we'd get it circulated, from the Office of Law or something, or from you?
I think at the meeting, it'll be public. It's a public meeting, so I think the document will be public at that time, and so you can get it after that, is my assumption.
Okay, great, thanks.
I have another question about what this covers. What about appeals from decisions about the Forest Conservation Act? We went through not long ago some refinement of the Forest Conservation Act to sort of remove this the ability of somebody to just cut down trees if there's been an appeal filed. Frankly, it's as simple as that. So would appeals from our decisions about Forest Conservation Act also be subject to this automatic non-stay?
The Forest Conservation Act is in what part of the city code? I guess that's a starter question. I'm looking for it right now. Is it in 21?
I honestly can't remember.
I have to look at it. I do know the answer, Bob. It's basically, there is an automatic stay from when it goes from the Planning Commission to the Building Board of Appeals. Strangely, it's going to the Building Board of Appeals and not the Board of Appeals. But there is a stay, so they can't.
Why would our decision on Forest Conservation Act go to the Building Board of Appeals?
Well, it's not my decision, believe me.
I'm not asking you.
Oh, I don't know. City council decided.
Why does that happen?
Who are you asking?
I'm asking either Mr. Jakubiec or Ms. Correa.
I don't have an answer. Someone thought that was where it should go, and that's why it's in the code, but I don't know why. Probably because it's cutting things down and it's forest, so it's built rather than a building. It's I don't know. I don't have an answer.
No, that's
And
one
that's
of the
something
mysteries.
that if that's something that needs to be changed, then we're happy to look at it and address it if that doesn't make
That's
sense.
one of the, the Building Board of Appeals is like a black hole.
Okay.
I'm sorry.
It's stacked with
Let
members.
me,
It has no rules.
let-
It issues sometimes strange opinions, like it doesn't understand, as Ms. Butler pointed out a few days ago to me. It recently decided that shall does not mean must. It means may. So I'm very concerned if any decision of ours goes to the Building Board of Appeals. Okay, that's one. And two, I'm concerned that if we make a decision about the Forest Conservation Act and then it goes, it should go to court, is what I'm saying. And then let the court decide on whether to issue an injunction or a stay. Okay, that's very important. Why? And that's a big hole in this legislation, is what happens with Forest Conservation Act decisions of either us or the Board of Appeals. Okay, we'll get to that. Record. What is the record? You guys, the Board of Appeals has much more experience with having to get the record together. And there's an attempt at defining the record, because these appeals to the court are, quote, on the record. There's no new trial. They're on the record that was made before us. What is the record?
The
In
record,
simple terms.
the record in simple terms are the documents that were before if it's a director's decision, the documents that were before the director when the decision was made. It's the any transcript of any hearing that occurred. If there were documents provided or exhibits provided during that hearing, that would be included as well. Any public comments, if there was any slideshow presentations, anything that was presented leading up to when the decision was made, that is included in the record.
Okay.
So whatever was used to base the opinion.
Does the legislation is drafted now, does it make that the definition of record, does it make it applicable to planning commission decisions also?
the planning commission decisions that are being appealed to the circuit court.
Yes.
And then the circuit court rules require that a record be submitted.
Okay.
And so it's not defined any further than that in these changes, no.
Okay.
But that's when it goes to the the circuit court first, they'll require a record to come from the department.
Okay.
And usually the lawyers, I believe this law department gets involved in looking at the
Yeah.
record before
Yep.
it goes over.
Mhm.
So the law department reviews it.
Okay. So defining the record is, for us, doesn't need to be in this legislation. It's the province of the circuit court. And the reason that there's a definition of record is because of the decisions that go before the Board of Appeals.
That's right.
Okay.
And
All
it
right.
helps clarify because there had been no definition of record. I approached the decision once and said, well, the record is everything I looked at or considered in making a decision. So the record constituted about 4 or 5 documents. Well, of course, the appellants said, no, the record is all these things because it helps establish the logic of your decision making and it provides the board with, and I said, well, you're right. That's right. So the record should be something much more substantial. And the chairman of the Board of Appeals is very helpful and actually in helping shape that. And then I think is very appreciative about the way we've defined record here because it helps clarify it. So he doesn't have to make the decision of what the record is in every case.
Okay, good. But it doesn't apply to us
Correct.
No,
because our record will be defined by the circuit court. Okay, that's off the table now. I have a question now. You said that the Board of Appeals has been active, as Ms. Woods informs us, that it's been active in formulating its own responses to this legislation? I mean,
yes,
it's going to independently tell the city council, what they like, what they don't like, what needs to be changed.
make a couple of recommendations.
Okay, good. All right. I do have one question that may, depending on the answer, it may get you may ask you to communicate it to the board. And that is, there's a record of what went before Mr. Jakubiec, okay? And then there's testimony now, which can be live and which needs to be pretty quick in time. Will that testimony then become part of the record that goes to the circuit court?
If it's appealed to the circuit court?
Yes.
Yes,
Okay, and any new information that's brought before the Board of Appeals in their hearing also will become part of the record and go to the circuit court.
yes. If it's appealed to the circuit court, yes.
Okay, I don't know that it makes much, I don't understand it, and I don't want to get into the Board of Appeals, bedroom, but they're saying that the director made an arbitrary and capricious decision. That's the basis for an appeal, right? Goes to the Board of Appeals, and they say, well, I don't know,
No,
we've
don't
heard
go-
new
no.
evidence, and we don't think, I don't know if I've thought this out clearly, but there's new evidence which is brought in, and a new decision is made.
Well, their review, the Board of Appeals is also on the record. So they're not really taking new evidence. They're going on the record of what the department considered when they made the decision that's being appealed to them.
Right, well, I can see some problems with that.
Yeah, because it's in that legislation, under burden of proof, under review procedures, the new 21.30.020. And the section that covers appeals, so that part of the new legislation, well, it's already that way, but they're just restating it really,
I'm just
that
saying
it's on
what
the record.
happens.
It was already on the record. That changed a few years ago.
Okay, I'm just saying it gets a little antsy when new testimony, new evidence comes before the Board of Appeals. And then, what is the record? I don't want to get into it any further because it's not really our province. I'm just pointing it out that I think that there's going to be some problems with that one. Now, finally, it takes some time. Let's say the Planning Commission approves something. And that gives the green light to a builder, developer, applicant to start cutting trees, digging up the earth, and doing all kinds of things. Okay, proceeding towards permit. Should there be, for the neighborhood response, we'll say, they want to take an appeal. They file an appeal. Should they get a certain amount of time to get the appeal filed and go before the court asking for a court stay or temporary injunctive relief? Should there be 30 or 60 or 90 days in which action stops in order to give people time to go to court? Or there's a denial by the Planning Commission.
By the Planning Commission. Well, there is a certain time period you have to make your appeal to the circuit court. I think it's 30 days after the decision. That's in the
Yeah.
Maryland rules. And so then you would have, your ability to go and at the same time you're filing your appeal, you could file your motion for a stay, whoever wants to file that. And then the court will make a decision, but it's kind of out of our hands. But that time limit is there. You have to appeal within 30 days of the
No, but
decision.
during the time that it's before the court and before the court makes a decision, will action within the department towards permitting proceed? We approved it. And
Until there's a
they
stay,
can
yes.
get the chainsaws out and go to town.
Until there's a stay, yes, they can.
Okay.
Is my understanding. Jessica, any difference?
No, you're right. And the person that's appealing, if they're worried about that, can file an emergency motion for a stay. So they have the ability to file something and ask the court for an exigent circumstance and to stop everything even faster, rather than just filing the regular motion to stay and it gets set in 30 days later. They have the ability to file an emergency motion. And then usually, depending on how quickly they can get in, it's, a couple days sometimes that they can get it in. So they do have that ability to do that through the Maryland Rules of Civil Procedure already.
Should they be given, as a policy, a certain leeway, a certain 30 or 60 days in order to get all of that together and file with the court? And in the meantime, they can't do anything. Nothing can get done on the application. That's a
So
question.
you're saying,
policy.
should there be a stay before the stay, is what you're saying?
Well, yeah.
Stay before you ask for the stay, just because, when you file in the circuit
Excuse
court,
me,
it takes a while.
Excuse me.
Oh, sorry. Sorry.
Go ahead.
I want to be clear about words. A stay is what's used down here on the city level. But a temporary restraining order or a more permanent injunction, or what's called injunctive relief, those are the words that would be used before the court. Okay, so yes, you can go, and a temporary restraining order, a permanent injunction, it's the same thing as a stay. It's just more refined, more detailed, more specific. Anyway, I just want to make sure that language is clear. So
Right, well,
it's
they
a
can
policy
file-
decision.
They can file a motion to stay. That's what it's actually called in the
Oh,
court.
yeah.
And you can file an emergency motion to stay. And
Okay.
that tells the court it has to be set in very quickly. And for example, I might be going to court tomorrow because one's going to be filed tomorrow morning and I might be in court tomorrow afternoon to hear it. So they do work quickly. They just have to know how to title it and file it with the court, but they have the ability to make it heard a lot faster if they file the proper pleading.
It's Maryland Rule 7-205 about stays when from an administrative agency to the circuit court. And it specifically said you filing a petition for an appeal does not stay an order or an action from an administrative agency, but the court can grant it. And as Jessica said, it could also be filed as an emergency with exigent circumstances, such as, the things you've described, somebody really changing the landscape of something that's up on appeal. So you make a very good point. And I guess your point at the end of the day, you're saying, could there be a stay before the stay the court grants? And I think what this legislation is doing is kind of taking that away. It was kind of happening before, but now it won't happen. So there isn't anything in place for what you're describing.
Okay, so the question is for either the neighborhood appellant or the developer appellant, should we say you've got a little bit of breathing room here? You don't have to run to court, immediately. I guess, that's an issue we'll bring up for discussion. Is there anything that you all, Ms. Woods or Ms. Carrese, anything you want to say to that? In terms of the policy logic or not?
Well, I think
You're saying, Ms. Carrese, that you can go quickly. It'll happen fast. You can ask for an emergency order. Okay.
Yes.
Okay, Mr. Jakubiec, what'll happen if the you know, if let's say either way, we deny or approve.
Well, let's think about it. First, when you deny or approve, you make a decision, you make it live at a public meeting. And then you have 30 days to write a written decision. As soon as you've made your decision at the public meeting, you've given notice to anybody who might want to appeal that you're likely to appeal. And of course, some people might need to really see the details of your written decision before deciding a course of action, but you certainly have given them notice that you're headed toward a decision. After you've decided, developers don't just go out and start building buildings. There are usually with your approvals multiple conditions of approval that take many, many months, if not sometimes a year, to comply with before we can even authorize a final approval of that plan and issue any permits. I mean, that's just permits for site construction, like grading. And then there's many months that go by before we would even issue a building permit for, constructing buildings. So the things that come before you have a bit of a lag time before actual construction takes place. Certainly 30 days is the time that you have to appeal to the circuit court. And, development activities don't happen in that 30 days.
What about actions under the Forest Conservation Act?
A little more challenging for me to answer. I don't know the ins and outs of that code right now.
Okay.
Bob,
what
I
you're
think
saying is-
it depends. It depends on what part of the Forest Conservation Act. If it's a variance, that's something we approve that goes right to circuit court. So that's, that we've already talked about that. Other parts are decisions of the director, and those would go to the Board of Appeals.
Well,
Building Board of Appeals.
Make a
The
decision
Building
on
Board of
the,
Appeals.
Sorry, Building Board of Appeals. Yeah.
oh, excuse me. Isn't that don't we also make a decision on the preliminary, I forgot, what was it, Forest Conservation
Yeah.
Plan?
Yeah.
Or stand delineation.
Mhm.
Well, there's that, and then there's also on the conservation plan itself.
Right.
Okay.
But those things are part of the approved plan. You have to have your plan approved, and again, there's approval steps that have to be taken. You can't take down the forest before you get your project approved and through the cycle and permitted.
Or you cannot.
No.
So we approve it on a Thursday, right? Issue the written opinion 30 days later. They have to wait until the entire plan is approved before they can do anything on site?
Yeah, they have to have an approved plan. They have to have an approved site development plan in order to remove a forest because that is part of the approved plan. It's just like they can't go and grade a site without getting the plan approved. And one of your conditions is for the applicant to be in compliance with all state, local, and federal laws and regulations. And one of those is the Forest Conservation Act, and the two work together. So once your approval is granted, there's a period of time where the work is underway for permitting, and that takes some time. Certainly takes more than 30 days. And
So
giving an appellant time to decide to appeal. And of course, they have to appeal first before they can request a stay, I would imagine.
Ms. Butler?
I was just going to say, maybe, Bob, we're not likely to see another Rocky Gorge where they came in on a Saturday and cut down all the trees and then said, whoops, we're going to appeal. That won't happen anymore. It sounds like it. It seems like our planning zoning department is really on top of this stuff too, and that kind of thing wouldn't happen. But it has happened in the past. So hence some of these questions.
Yeah, but that project did have an approved plan, approved.
And it was being
Right,
appealed, right? And before they even got to the circuit court, they came in on a Saturday morning at 10 o'clock and started bulldozing the trees, and no one could stop them. Planning and zoning wasn't working. It was just And still today, we have a whole lot of, open lot that's not covered, that drains into Aberdeen Creek, that's hurting the environment. So anyway, we're just saying that won't happen anymore, is from what we understand.
Yes, that's our concern. That's our concern. Okay, I mean, I think I've said what I have to say or asked what I need to ask. I'm really interested in what anybody else has to say or ask. It's a complicated, I prepared a flow chart. I don't know if it'll be of any help. I don't know. I don't know.
Bob, I was just going to ask, is there a flow chart that lays out all these commissions and boards and who and a reporting scheme for that's required and so forth, particularly as a new member? It would help me tremendously if there were such a flow chart.
Well, I think I can answer part of your question, and that is that this legislation applies only to the Board of Appeals, the Historic Preservation Commission, and the Planning Commission. The Liquor Board, the Port Warden, and the Building Board of Appeals are not included in it. Okay? All right. Even though, well, and then, well, I mean, I prepared it. It's a little complicated. You want to take should I put it on the screen?
Yeah, that'd be great.
All right.
Please.
And Everett, you have access to the drive, to the Google Drive, right?
Yes.
Okay, it's in there as well.
Oh, it is? I didn't see it.
Quentin.
Sure. You want me to share my screen?
Yeah. And it's the flow chart visual.
Yep, I got it. I have I'm always ready with the materials up. There we go. And can you all see my screen?
Yeah, but can you make it bigger?
Yep, I'm working on it.
There. Okay.
And then also from each person's perspective, if for some reason you want to make it even bigger, you should be able to hold down your control button and scroll up, and it should make it larger on your own screen as well.
Oh.
Any way you can convert this to type?
Oh, stop. And Mr. Bell.
Instead of print it, I can't read this.
What do you mean?
Bob's going to explain. Go ahead, Bob.
All right. At the left-hand corner, Board of Appeals, PC, HPC. Let's say they deny the application. Okay. If the application's denied, the applicant is going to make the appeal. Right. Okay. The application's denied, no work can take place. Planning and zoning is not going to do anything towards the permitting, according to what Mr. Jakubiec says.
That's right.
Okay. The appellant then, of course, according to what Ms. Carre says, seeks a stay quickly. And the court needs to move by their rules within 3 to 5 days, is my recollection. Now, let's say the court then grants to the applicant the stay, in which case our denial is stopped and the work can proceed towards permitting. Okay?
Except that in this case, the work has been denied. The application has been denied.
Yeah, right. So the denial is stayed, the work can proceed. Wait a minute. The court grants a stay of the denial. It grants a stay of the denial. If the court denies the applicant's request for an injunction, because basically, okay, then the denial by the Board of Appeals or us or the HPC remains in place. They deny it to the applicant, okay, the appellant. Move down.
Sure.
Let's say we have approved an application. We appeal to the circuit court, okay? The appeal can be made by an aggrieved person, okay? And there's certain court definitions to my understanding of what an aggrieved person is. Later, we could ask, Mr. Jakubiec or Ms. Carase what that means, but let's say it's the neighborhood person. Okay, we've approved the application. They want to appeal our approval, but in the meantime, work can proceed until the appellant seeks a stay of our approval. Let's say the court grants their request for a stay. Okay? Our original approval is now stopped. See how it goes back and forth? It's like a tennis match or pickleball match. Work cannot proceed. The neighborhood appellant goes to court asking for a stop to everything, and the court denies them. Our original approval is not stopped, and work can proceed. Now, I don't know if I've made it any better or if I've made it worse.
Mr. Chairman, may I add one thing that's relevant here?
Yeah.
If the developer or the builder proceeds with work after the stay is denied and is entitled to proceed with work, they proceed at their own risk, because it's conceivable that the court will rule in favor of the appellant, and then the applicant has to deconstruct what was built, right? So it's generally the case that it's not in the interest of the developer or the applicant to actually proceed when things are being held up in court and being appealed. So there's that reality that comes into this process as well.
Well, I think there's another reality, which is sort of a shadow reality, and that is that in order for them to proceed, they need to start getting all kinds of permit approvals.
That's right.
And it may be that people, that the file gets lost for a while.
That doesn't happen.
But work can slow down. Anyway, I'm sorry that it's so complicated in a way that actually is not, once you sort of get the feeling for it.
Mhm.
If we approve an application, it's the neighborhood that's going to respond, that's going to appeal. If we deny an application, it's the applicant that's going to appeal. And that kind of helps. All right. Mr. Bellum, help me out here.
Me?
Do you have any questions? Are there any questions as to what the consequences of this are?
No, I was kind of curious. I was going to ask either the attorney for the city or Cheryl to tell me or tell us how often they see developers have to deconstruct part of any development that they proceed with, under this theory that they do so at their own risk. Has the court ever said, sorry, you just built that house, now you're going to take it down because we find that you violated some zoning or some building ordinance?
Well, what happens is when something is appealed to the circuit court, the judge in the petition for judicial review will either say that the decision of whatever agency is being appealed was either correct and it stays, or it could be remanded back. So the judge isn't saying what has to be done. It's either what the decision of the HPC was right and it holds true, or it has to go back to the HPC and they have to relook at their decision. The judge isn't saying, take this down, put this up. It's only looking at the decision that agency made and deciding whether it was based on relevant facts and supported properly.
And if it wasn't supported by facts, or the law was just misinterpreted, how often have you seen, or do you have any anecdotal stories about developers having to take down anything they've built? I just haven't seen it, but I'm sure it has happened. I think of the big just a couple of big developments where the developer did lose some major decisions at the end, and that was already built. So they said, well, what are we going to do? Make them tear it down? And they don't. So I'm wondering, as a practical matter, whether that theory that the developers proceed at their own risk really means anything.
Or Ms. Butler, in the example you gave, could the court tell them, okay, you cut down all those trees, plant a new tree for every one you cut down?
Well, that's what I think, that's what I want to make sure is understood here. When things are appealed, when the decisions are appealed, the court is not making a decision as to if things need to be planted, things need to be built. The court is making the decision as to whether or not the decision made by Planning Commission, Board of Appeals, HPC, if that was a essentially fair, accurate, supported decision.
So say no, but the developer has already started to build. I'm just saying, in your experience or in Cheryl's experience, how often does the court say, oh, well, you know, you've built something now, we say it shouldn't have been built because of, you know, that it wasn't supported by the evidence at the lower administrative appeal. Does it ever come down? But just a yes or no. Have you ever seen it?
Well, let me say this. I understand what Jessica's saying. She's saying the court wouldn't do that. If the court deny or overturns a decision of the department or the agency decision, then the agency will have to deal with what's been built, what should happen. The court won't opine on that. So we haven't seen it because they won't.
Because so if the court doesn't opine on it, and like you said, it gets remanded or booted back to an enforcement agency. In your experience, does it ever happen that the developer actually has to rip down what they put up?
I haven't seen it, probably because of the long process of permitting and all those other things that the director was talking about earlier. And Jessica, I don't know.
I mean, I've not heard of that happening, but it's possible that it could happen. I think that's probably impractical, but it's always on a possibility on the table. So to say that can't happen, you know, I don't want to say, you know, that's not the case, but it's definitely a hard step. It's definitely a hard step.
I get it. It definitely seems like it could happen, but I just was surveying friends of mine who are in the legal, you know, lawyers, and like, we've never seen it actually happen where the developer took the risk, you know, something happened, they got reversed, and then they actually were made to take it down. I was just curious because I've only had a tiny little experience with this and you guys have a broader experience. So thank you.
Yeah, the thing that worries me there is not something that's possible to reverse, like tearing a building down. That's easy enough to do. It's probably easier than building it. I think the biggest problem comes when an action's taken that's irreversible. So, you know, for example, cutting down mature trees. Yes, you know, the city could make them replanted, but it's not the same. So and
it's not likely. Yeah.
Well, I mean, that aside, the kinds of scenarios that bother me are actions that are essentially irreversible. And you know, and then you can't put that genie back in the bottle. So while I have the floor here, so I had sort of a question that, you know, I'm trying to boil this down to something simple that I can get my head around, is that, you know, these rules sort of try to balance the rights of parties on both sides of a disagreement. Fundamentally is what we're talking about here. And, you know, automatic stays that could be in place for a long time, because of, you know, it takes a long time to get something done or whatever, that sort of biases it one way or the other, sort of depending on whether you like it or not like it or whatever. And so the question I have is whether these changes here are essentially an attempt to balance the rights of both parties, to make them sort of equal. Is that a good way to look at this? And do the legal minds in the crowd look at this as sort of bringing more parity to both sides of the disagreement?
I think it works to clarify what everyone's options are, instead of having some unclear assumptions on what a stay is or what it should be or when it starts. for the old language. This makes it a more streamlined process. If you want something stayed, you have to file it with the court, which makes sense because a lot of times when you see petitions for judicial review, they also file motions to stay with it. They usually are filed simultaneously. So it makes sense. And then also, it's also clear because you have a judge's order, telling you one way or the other. It's a unbiased, third party. It's the court deciding whether or not this stay should happen.
Okay, thanks.
I have
Jessica?
a question on. Oh, sorry.
Sorry, Commissioner Butler. I thought I had a question for Jessica. When the judge is making that determination, does the judge hear from both the appellant and the other party?
Right. So the motion to stay, typically, not all the time, it depends on, because there's briefs, right? So someone will file a motion to stay and have their argument in there. Then you can file an opposition. And typically someone usually requests a hearing, so then you can have an oral argument. But sometimes if the judge thinks that they don't need a hearing, they might just automatically rule on it. But typically it's set in for hearing, 30-minute hearing, motions hearing, where both parties get to essentially verbalize and do an oral argument of their positions, which were already drafted and submitted. And then the judge might have some questions for each side and then make a ruling.
Thank you.
Should I go?
Mueller?
Okay, I have a question on page 3 of 7. It's section 21.30.202. I just want to clarify that an appeal may be filed. It says appeals may be filed within 30 days of notice of the planning director's decision. And I wanted to say, can we make sure it says the decision that has been filed and notice given of the decision to interested parties? Because let's just say it's a minor site design review matter. I know one time I was involved with something where we had to keep checking the website every day trying to find out when the decision was made because there was no notification necessary under the code. So is there any way to just include language there that says that the planning director, and we should include DPW because Department of Public Works decisions are also appealable, I understand, in this legislation attempts to deal with it. So those decisions by the planning zoning director or DPW director that have been filed and notice provided to the parties to the matter, that starts the 30-day clock ticking. So that's on page 3 of 7 under 21.30.202 procedures.
Who are the
I
interested?
guess I direct that at Chris Jakubiak, Director Jakubiak.
Who are the
just-
quote, interested parties?
Well, so that's
Anybody who's given testimony?
yeah, or writes letters and says, basically we think that this fence shouldn't be built around this development because one of the conditions was to allow access, and clearly a fence, for instance, would block access. So that would be a party, but it's not a party in that there's a suit or a formal appeal, but it's a director's decision that's very fundamental to a project. So the parties would be the people that are writing in and asked to be heard.
So what I've seen in practice is that the city attorney or the town attorney is contacted as soon as the appeal is made, and considers the appeal valid 30 days from the time that the decision was made public. And I often see that as an agreement between attorneys. Even when it looks like 30 days may have elapsed, if the issue is one where the matter has not been publicized, the applicant would not have had a chance to understand the decision and then couldn't decide to appeal. So, but I think there's I think because this issue came up in a recent case here in the city, I think there's guidance in state law about this. I would refer to Jessica Carres to offer some testimony in that. The only thing that I would hesitate to do is to add additional requirements that are easy to run afoul of, and then create more appeals of procedure. I think it's generally understood that the decision is made when it's made public, when it's uploaded on our system or whatever technique that the administrative body uses. But that's just my, practical understanding. And I defer to the attorneys who might be able to shed some light on that.
That would be great. I'd love to hear it because I have seen the other side of that one.
So I
Just say
think-
real quick, Jessica, just before you, because I'm not going to say much, is that it's usually, to make it definitive, we usually say it's the date of the decision, and usually it's uploaded or whatever that same day. But just to make it definitive, that's what we tried to do. And that doesn't always work, as you pointed out. But go ahead, Jessica.
So I was gonna say when it comes to interested parties, it depends, because there is language in the Maryland rules that talks about who those parties are depending on what the issue is. But typically with like a court case, like in circuit court, right? Let's say you have a decision that was made by the HPC and it's appealed. Then one of the things that we do, the Office of Law does, is when we make the record, we also make a list of interested parties. And all those interested parties are people that have either part of the actual appeal or testified or submitted an email that had an opinion. So anyone that had any type of stake in any of the hearings, not just there listening, but like spoke, and you're supposed to sign in. So you're supposed to have everyone that's interested or that actually was involved, because essentially when they go to circuit court, we tend to try to make an argument, depending if we can or not, on standing. And those people, to say that they have standing, had to have been at the hearings where the decision was talked about and made to be able to say they are an aggrieved party with standing. So it's really going to be a long list of people, usually are the interested parties, and putting it publicly, publishing it, that's notice to the public. So any of those people that went to those hearings can look at it and click on it and see it.
So that's very helpful. And I agree, that makes all the sense in the world. And it's been that way for a long time. But what's interesting is when the department director of planning and zoning or Department of Public Works is making a decision internally on something really important, and there is no public notice requirement. So it's a minor modification, which could be a really major modification, but under the minor modification rules, they don't have to put notice. Then we're left, or citizens are left to just, residents are left to just spin the, it's kind of a rumor mill. I saw so-and-so and so,
Right.
and they may have gonna be, the director may have ruled on it. Did you check eTrack-It? Well, eTrack-It now has changed to another thing. How are we going to find out? Then no one from, the Office of Law, or sometimes, the Planning and Zoning Department will respond directly to that question. They just say, wait till something's published. It's really not a good system right now. And I'm hoping that, since we're doing a great job clarifying a lot of these things, clarify that it must be a decision that's noticed, a decision made by the Planning and Zoning Director or Department of Public Works Director, and noticed in a way that gets to the interested parties. And even if the interested parties are those people that wrote in and asked, what are the, when is this going to happen? There's been a community meeting. How do we know? Yeah. So I would just ask that we clarify that to say publish, not just the decision 30 days from the decision of the Planning and Zoning Director and Department of Public Works Director, but notice and publish to the parties. I mean, parties is the best word I can think of. Interested people.
Well, we have that exact situation right now, don't we? Don't we have a case like that where there was a minor modification and they're saying, yeah. So
That's the Board of Appeals issue right now.
Yeah, we have that. So I understand what you're saying. I'm just not sure. The notice shall clearly state the grounds. Okay. That's a notice of appeal. Yeah, Jessica, I don't know if you have, I don't know how to,
Well, that might be something we have to talk with planning and zoning internally to see functionally what would make the most sense. And practically speaking, what would make the most sense. And then once we kind of know how we want it to work, then we can maybe figure out a way to add the language so it works that way.
Okay, thanks. I just don't want to hold anything up. And then I had a comment also on section 2130.020 B4, which requires the building board of appeals to render a decision within 40 days of the hearing. I just think that it should be clarified that it should be something like the date of the last hearing, because for the Board of Appeals, sometimes they have several hearing dates. You know, the hearings happen over, and that for us as well. You know, we can have a hearing on a project and it takes more than one hearing. So you would want to say that 40 days begins from the date of the last hearing. Okay.
But to be clear, the hearing is continuous. It's one hearing. It starts and it continues until it ends. We don't open up another hearing on a matter. So this language kind of embraces that understanding. And the hearing opens up and it's continued until it's concluded. If there's another hearing, then a whole nother public notification process has to kick off, and with notice delays and things like that. So in my way of administering the code and thinking through this actually works out just fine. There's just one hearing. It starts, and when
and it does say the Board of Appeals shall reach a decision within 40 days of the date of the hearing. It doesn't say, so you're saying the date of the hearing is clear to you that it's the last hearing, even if it's a series of hearings, because it's all the same hearing. So you don't need any further clarification. Got it.
Thank you.
Yep. And then my last question is, so there was a recent decision in a building board of appeals case that talked about the word shall versus must. And I was wondering if we need to go through this carefully and wherever it says shall, put must, because if shall is considered ambiguous now by our city, it's really going to impact not only this legislation, but findings we've made in the last even year, 2 years, because we use shall often and we mean must most of those times.
Ms. Carres?
I haven't seen the decision by the Building Board of Appeals that says that shall does not mean must. So if you are worried about that, we can note that, but I haven't seen that decision. So I don't know how they came to that conclusion or what that's in regard to. But I would just say if that's something you'd like to be noted in the notes that are going to be provided eventually to us regarding the legislation, you can add that to the list of notes of comments that you have.
Is it not?
Well, I mean, we just have to change it all because we do, and I don't know if that's going to be a standard that the city sets for all legislation that's written now. Do you have any sense? Or maybe, Cheryl, do you know?
well, no, I don't think so. I think this is often, rules and procedures often use must, may, or shall. Shall give some wiggle room, because even if there aren't written exceptions, sometimes there's a need for an exception, that it can't be done for some reason within the 40. So it gives the entities a little room to argue that it couldn't be done for whatever reason, this reason or that reason, even though there's no written exception. Sometimes there's just exceptions. So shall give some wiggle room. May means, as we know, you may or may not be able to do it.
Yeah, no
And
one's
must,
arguing about may. We're just trying to make sure we use the right wording. And we've written a lot of things in the last, in 2 years, 3 years, where we say shall, thinking it means must. And I actually did get to go through this completely and change it, but we should probably do it for this. If there's going to be an argument that shall is ambiguous, change it here, and then even go back to anything we've, done in the last, 3 months, 6 months.
yeah.
Ms. Carres, do you have any observations on this language?
Well, Ms. Wood is the counsel for the planning commission. I advise planning and zoning department. So I'm gonna have you guys default and talk to her for advice on the shall, must, may.
Right. I think there is I think there's even a Supreme Court case that says that shall really means may. And I think, you know, I can't cite it right now, but I think there's some information out there. And so it just depends. You may not always want to use must. There may be reasons to use shall at times. So you would have to go through each one and make your recommendation.
Well, I would
But
say
I
we
don't
never
believe
have,
that-
we,
Hmm?
I'm sorry, we just never knew that there was any ambiguity. So we've been operating a long time that shall means must, and I think so have most of the boards and commissions. So it's really important that the word spreads, that that's no longer the case, and we can go back and correct things where we really did mean must.
Yeah, and I think if you mean must, you need to say must.
Okay. Maybe we can go through AI and put everything that we've done, bulk of work in the last 2 years, to figure it
I mean,
out,
it's
because
going to
this is
be
gonna be
too
crazy.
late. It'll be too late for them to do anything about stuff that happened 2 years ago anyway, right? So, it's okay. But legislation and, I mean, if we need to look at the city code, probably going to be a lot of shalls in there. But my only point to make is that shall does not mean must. So if you think something should be must, then I would make that recommendation that it be must. But it is ambiguous, I think it's kind of strong, but that's probably right. And I
When
think
you
a
said
lot
the
of people,
Supreme Court, were you talking about the Supreme Court of Maryland, or what court in Maryland do you think
U.S.
made that
Supreme Court, U.S. Supreme
Okay.
Court. Yeah,
Okay.
I'm not sure about Maryland, but I know there was a U.S. Supreme Court decision.
Yeah, I found two here. There's they both date about 150 years ago. One's 1876, the other one is 1877, Railroad Company versus Heck. But yeah, where they kind of say it's really confusing to read, but essentially says that shall means must for existing rights, but that it need not be construed as mandatory when a new right is created, as one of the examples. And that it is definitely something that is
Yeah.
is an ambiguous and confusing word for many, and when used in legal documents is what this is saying.
I think in 1995, there was a decision, Gutierrez, De Martinez versus Lamagno, I can't pronounce this, Lamagno, like, I don't know, Lamagno, I don't know why I can't pronounce it right now, but 1995, that talked about this shall versus must. They even cite,
Oh, yeah.
they talk about Black's Law Dictionary, and that must is the only word that imposes a legal obligation that's mandatory, is the word must. And so we're taught, it even says in here, I saw somewhere that we are taught that shall means must, but some courts have not interpreted that way. So to be safe, I think you have to, if you want must, you have to say must. Because lawyers always want wiggle room. We want exceptions. We don't want to be must, because something might happen that we didn't anticipate, and we can't do this within 40 days. And what happens then if it said must? So lawyers like shall, because they like to have ambiguity and they like to have some wiggle room. So that's why you see shall so much. But
And
doesn't-
someone mentioned that this issue came up in a recent case in Annapolis or Maryland.
yes.
Yeah,
What-
the decision is December 6th. I sent it around. I'm not sure who got it, but it's a matter, it's called in the matter of offense 2024-00042 relating to property at 301 Georgetown Road.
Yeah.
And I have the decision in order if anyone wants to read it.
Yeah, I remember that. I know that one.
And what was the decision in that case? I will read it, but what was the decision in it?
I can't remember. It
was about a fence, and it says, there's no clearly defined rule in the code which indicates that if minimum requirements are not included in a permit application, the Department of that DPZ cannot approve the permit being sought. In fact, the code states that these requirements shall be included in the application, not that they must be included.
No.
Well,
So
that's
in that case,
minimum.
it's pretty clear that shall means must in that case, but
Right.
so
but
Anyway,
thank,
that I'll circulate it if that helps, Everett. It's interesting.
thank you.
All right.
Please.
My
do.
point
All right,
is, if you
in order
wanted
to
to,
conclude this conversation,
yeah,
Yeah.
I think that whoever is going to do anything about it, to make a motion about it, is that you need to go through the proposed legislation and look at every shall and decide whether it needs to be a must or whether it can remain as a shall. Okay? We're now educated on the issue, and now the question is what gets done about it.
Yeah.
All right. All right. What else? What else? What else? What else? What else could we possibly want to talk about? Okay. I'm prepared to close the public hearing on this issue, this matter. Okay, public hearing is closed. We can now enter into discussion. If you don't mind my leading off, I usually don't like to lead off, but I think we should stay out of the Board of Appeals business. I don't know if 40 days or 45 days is the right number or not the right number. I mean, they know. I don't know. They know what needs to be clarified about record. I don't know. They know. And so and they're certainly having the opportunity to comment on this legislation. And I would propose that one of our findings be that we defer to the feelings and the perspectives of the Board of Appeals, and that we're not making comment on their issues. We'll get to that in a minute when we actually start voting on things. But that's my recommendation: is that it's not it's their business, not our business, and they're perfectly capable of speaking for themselves. I think that Alex Klein raised a very interesting thing when he said, is this an effort to provide sort of equity or clarity or equality in some way to balance things out? And I think that I'd like to talk just a short bit about that. And I think that it definitely is, because the experience that we've been having over the past 5 years is that an exceedingly small minority is able to tangle up in court a decision that was made by a very clear majority. And so that you could have one person who funds an attorney, or you could have one person and other people fund an attorney for that person. And they can hold up the Village of Providence Point. They can hold up the Eastport Lofts, and they potentially could hold up the city dock that we just approved our opinion tonight. And they could file an appeal tomorrow, and it's automatically stayed unless unless this legislation is passed. It could be one person. And so at least it gives it sort of opens up the field, and as Ms. Correa said, it kind of clarifies exactly how the process is to work. You want to appeal it, you got to go to court and ask for that injunction, that stay. You might get it, you might not get it. But when you go to court, you're going to have the city who's hopefully supporting our efforts, our decision, the Board of Appeals decisions. You'll have whoever's on the other side as a party, and that it'll be a more open hearing and a more open process than an automatic hold through the circuit court and then the Court of Special Appeals, and then maybe even petitioning for cert to the Supreme Court of Maryland. It's like holding things up for 3 or more years. So that's all I want to say on that.
Yeah, just
Really be interested in what you
to emphasize about that, the litmus test I always use in these kinds of things is, sure, if it's a little bit lopsided and something that I have, that I'd like to see go a certain way, for example, I always like to try to flip it around and look at the mirror image and say, well, you know, if somebody else were trying to do that, would I still think it's the right thing to do, even if it went, you know, against something I'd be interested in? And you know, these automatic stays that last a long time, you know, I think in some cases I might think that's a good thing, but you know, if I were on the other side of the fence, I might not. So you know, in thinking about this, it does seem more balanced the way this is proposed. And the fact that you can always go to court and ask for a stay, you know, either way, you know, regardless of whether it's, you know, benefits a developer or the city or whatever, you can always ask for a stay if it's really important that happen. You know, for example, the thing that I used about making an irreversible change. You know, if that's part of the thing that's likely to happen here, you could go to court very quickly and say, hey, somebody's going to make this, you know, start on something that that you cannot undo. Please, court, you know, take that into consideration and stay. So I think the fact that that avenue is available, and I'm not a lawyer and I don't know what's involved in doing all that, but it seems sort of it's, you know, de rigueur for lawyers to be able to just go do that. You know, this to me seems pretty balanced, gives everybody the same opportunity to do that. Okay, that's all I had to say on that.
Mr. Riley. Mr. Cummings.
Yeah, I don't really have much to add other than I agree with the comments that you, sir, and Mr. Pline have already said here. There's plenty of inclusion from all parties all throughout this process that I don't think that the ease at which a very small number of people who otherwise didn't get their way to continue to get automatic stays is necessarily good. There's a process that they can go through in order to get that stay if there's a real problem, and I think that's fine. So I don't see any problem here.
Yeah, I'm the only reason I haven't said anything, Bob, is because everything that you've said, and Alex certainly has chimed in, it's just common sense to me. We shouldn't allow the few to disrupt the flow of the many, and we already have process, so make them go through the courts if they don't like the situation. I don't know what else to say. I agree with everything everybody said.
Mr.
Yeah,
Booth?
and I like the idea of deferring to the Board of Appeals since this really impacts them the most, but I also like the fact that this clarifies as what's her name? Jessica was saying, just the code itself, because there was some ambiguity in the law currently about whether the stay was automatic and some other procedural issues related to it. So I think it probably is a good thing. I definitely think there are some, you know, issues we have to include in our comments, which we can go through now or go through as we vote.
Mr. Bellamy?
I think this is a good balanced approach to different parties' interests, and it's a good way of dealing with it and not letting, as has been said, not letting a single individual or person who objects to hold things up. I think this is a good approach.
Okay. I would propose that as we move forward, that first of all, we vote on some findings and to clarify what our findings are, so we don't just leave it up in the air. And then we can vote on at the end, we can sort of vote on the whole package. I would move okay, first of all, that our first finding is that we defer to the Board of Appeals, and that we make no recommendations as to the portions of this legislation that affect them alone. Okay, do I have a second on that? Finding number one.
Second.
Okay, any discussion about you think that we should talk about? Or do you think that the deferral is good?
I'm good with it.
My
Mr.
only problem is that they don't get to vote on this. We do, so I wish we could defer to them by getting their comments and then voting in favor. But since that's likely not to happen, I'm okay with the wording you have suggested.
Yeah. Remember, all we're doing is making a recommendation, and all they're doing is sending in their comments, and not formally a recommendation, but I'm sure that they'll be considered. All right. Any further discussion on finding number one? Okay. All in favor of that, say aye.
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 Okay. Passes unanimously. Another finding. Well, I'm very concerned about the Forest Conservation Act stuff. I'm not quite sure how to put it into words yet. I'm somewhat comforted by Mr. Jakubiec, who says that nothing can proceed on site until there's a final approval. I just think that we need to express, or I feel that we need to express our concern that Forest Conservation Act, that there can be no, how do I put this? There should be no violations of the Forest Conservation Act in the absence of any kind of stay. I think I got that right. I think I got that right. All right. Yeah, I mean,
I don't quite understand that second part of that statement, in absence of any stay.
right. Let me, you guys talk about something else. Let me try to scribble some things down, see if I can't get it straight. I don't think we're concerned that people can violate, can in the absence of a stay, I'm concerned that people can cut down trees, they can, it's not that they're violating the Forest Conservation Act. I mean, we've decided something, they've taken an appeal. The court has said they have not granted the city's request for a stay. And so the applicant, feels that they can proceed, and they come in on a Saturday with a team of people and cut down everything in sight. How do I distill that into language?
Yeah, I would definitely be in favor of trying to prevent that sort of thing from happening.
Yes, but how do we distill it into language?
Yeah.
Is a finding, we can express our concern that in the absence of a stay, that people can perform acts that are inconsistent with our decisions on the Forest Conservation Act. It's like I'm using too many words. It needs to be clear, simple.
Can we ask Cheryl to find the right words and just give it back to us in a way that I can put into the findings? And that will give her the opportunity to look at the Forest Conservation Act legislation that was just modified.
Well, we can start off with expressing our concern that acts in the absence of stays sought by the city, that detrimental actions can be taken under the Forest Conservation Act. And then,
Or irreversible, or whatever.
Yeah, irreversible actions. And if that's a start that Ms. Woods can use to sort of formulate something. My recollection of the Forest Conservation Act is not as fresh as it once was. So I can't remember what, and I can't remember what it recently we enacted or recommended approval of those changes to that, to the appeals inside the act. Okay. Ms. Wood, you ready to give that a go at some point? Come back to us in 30 days?
Yes, of
Okay,
course.
great. All right.
I would like the language that indicate they would not be allowed to do anything until the final appeal process is taken place.
Yeah, it's kind of like we're asking for an exception for actions, you know, forestry, tree actions detrimental to trees and forests. Okay. So finding number 2 is that we're expressing our concern that irreversible actions can be taken in the absence of a stay. And secondly, that we're asking, at this point, we're asking Ms. Wood to come up with a formulation that we can vote on in 30 days. All right?
All right.
That's where we're at?
Mhm.
Okay. I move that. Is there a second?
I second.
Second.
Okay. Any more discussion? All in favor, say aye.
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 All right. Finding number 3. Does anybody have anything here they want to add?
Yeah, I think I want to add that on page 3 under 2130 202, clarify that an appeal may be filed within 30 days of notice of the planning directors or Department of Public Work directors decision filed and noticed to interested parties. Because there's no other way to know when there's a decision made by a department director. And so you wouldn't know when you can make your appeal if you don't know when the final determination is made. So we just need language just clarifying that.
And the language is?
So it would say notice of the decision provided. So I'm inserting on page 3 of 7. Hold on. Of 7. Of course, I'm doing this in paper. So number A1 says appeal may be filed within 30 days of the decision being challenged. And this is under appeal procedures, planning and zoning, administrative enforcement. So basically under 1A, it'll say the notice of appeal shall be submitted to the director of planning and zoning. And then the notice shall state the grounds for the appeal, which may include blah, blah, blah. So that part isn't the problem. The problem is talking about when the appeal may be filed based on the decision. We have to say that the appeal may be filed within 30 days of publication and notice of the decision to the parties. So I would just insert the language under 1. So A1, 30 days of the, and then insert publication and notice to the parties.
Who are the parties?
Is this for the Board of
We just-
Appeals?
Well, it says it's under Title 21, Administration and Enforcement, but I believe it talks about the Planning and Zoning Director, but it should also appeal to the Department of Public Works because, you know, the legislation deals with not only Board of Appeals, Planning Commission, but in the preamble, it talks about Department of Public Works as well. But none of these other procedures have been talking about the Department of Public Works director's decisions. But it's the same kind of thing. They may make a decision on adequate public facilities, for instance, and no one would really know that because it's an internal, you know, reporting or certification process. So no one can determine when to make an appeal or when they can appeal if they don't know that the decision has been made by the administrative authority.
If I may
So we just
point-
need to clarify it by saying publication and notice to parties.
if
And
I-
parties, I'm just having a struggle with the word parties, but I'm interested in anyone else's concept. Interested people, because they're not technically parties.
I'm going to point out two things.
What's that?
I want to point out two things.
Okay.
One of them is that clearly we've had a lot of problems determining who are the interested parties to a decision that's made by the director of P&Z or Public Works. It's like, who are the party? The only party is the person who made the application. And the second thing I want to point out is that Chris Jakubiak said is like, if you put in formalities in terms of procedure here, it just means more appeals based upon, well, I'm an interested party and you didn't send notice to me. And I'm an interested party because I live 3 blocks away. I'm still interested.
Well, just say parties who would
Who
have
would?
standing under the law.
Wouldn't
That makes it
stand
clear.
under
It
the
can't just be somebody from another town saying I'm interested.
law. I have not heard a practical suggestion as to how decisions of these departments can be made public and everybody knows it. I haven't heard
Not
of
everyone. People with that, I just think there's got to be language, publication and notice to people who have communicated directly with that department on this issue. How's that?
That's different. That's a more precise definition.
Okay, I'll insert that.
So finding number 3 is that whatever that place is in the legislation is that notice of departmental decisions shall be made to anyone who communicated directly with the director of planning and zoning or public works.
Perfect. Thank you for that.
Okay. Is there a second to that motion?
A second.
I'm not making it. Ms. Butler's made it.
Yep. Ms.
Well, I guess
Butler,
I
read it
can't
one more
second.
time just so that I can hear
Can you
what the final.
restate the motion?
Thank you.
Notice of a decision by the directors of planning and zoning or public works shall be made to persons who communicated about the issue to the director of planning and zoning or public works. So that notice is given only to people who communicated directly on the issue with the directors or director.
And I would just say not only, because you are going to be hopefully publishing it on, it's not e-track anymore, but whatever it's called. So once it's out there publicly, it's
No.
not like just limited, obviously.
No,
Right.
no. It's after it's published, okay, and an appeal is taken, then people can communicate with the Board of Appeals. You're talking only about the decision of the director.
Right.
And
Okay.
that wouldn't belong in
Interested
this.
parties is defined as people who communicated about that issue with the director.
Perfect.
After he's made that decision and he's let them know that he made his decision, it enters into a new stage.
Then they have 30 days and they can't whine about it after 45 days. Oh, sorry, we didn't know, because the director will have said, hey, we made this decision.
Well, if you communicated your feelings, there's a notice put up. There's a board, a signboard put up that says, when somebody wants to build a fence or a outdoor sauna or whatever the hell is going on, there's a notice going on. People communicate that to the director, okay? It's easy for him to keep a log. He notifies just those people as well as the applicant. Those are the people who get notice. That's all.
Okay. Can I?
There's an appeal taken to the Board of Appeals. People can make their comments to the Board of Appeals, blah, blah, blah. We talked about that as the record, okay? Okay,
Got it.
question,
So-
any questions, Mr. Cummings?
Oh,
Nope.
no.
I'm
Okay,
good.
did I clarify it or unclarify it?
No, it's clear. Thank you very much.
Mr. Bellamy?
So this is after the public notice is issued,
No, this, at the same time as,
the same time as.
Simultaneous. Yeah.
right?
Oh,
So,
okay, got it. Okay, then I'm cool with that. Yeah,
and that the only people who get like personally touched by it are the
okay,
people who communicated.
okay, that clarifies it for me. That's fine.
Good question. Mr. Klein? Any comments?
I'm still having some trouble with that. Like, it just seems like an administrative nightmare to keep track of that kind of thing. I was just trying to think if there was some existing communications channel that is not it's a push, not a pull. That's the problem with posting stuff on websites, is it's a pull. You have to know where to go find it. I'm just trying to think of some other mechanism that's more of a push mechanism that they could say, hey, this decision's been made, and push it out, and then people could get it. But I'm not coming up with anything. Whether it's the press release, or if planning and zoning has a mailing list, like I mean, that's maybe a question for staff. Is there some mechanism like that's more of a push mechanism that could be used, versus having to have staff keep track of people that have emailed or called, or that seems to me fraught with, oh, well, I called you, but you didn't write it down, and to just kind of.
What about communicated in writing? Because I think you're right. That would be a nightmare trying to catch up with everyone who's made a phone
get my
call.
call or my email. I sent it to you. You didn't get it. You can see that sort of squabble. So maybe something like that. You have to ask for, send something in writing saying, I want to be notified of this. So something where there's enough friction there that it, somebody's got to really want to know that, to take that effort to do it. And then there's literally a paper trail. So maybe that's the way to go.
Yeah.
I think
So,
Ms.
Ms.
Gooby
Bell,
had
you
his
set
hand
that amendment to your motion that people who have communicated in writing, does that include email?
No,
Oh, no?
I mean, because
Make it a formal,
Okay.
make it a formal,
I sent my email. You didn't get it. You must have lost it.
no, formal form. Yeah, of course.
Yeah. If you care that much about it, you'll write a letter and put a stamp on it.
So a snail mail or certified mail or some kind of mail that's not just email. Okay.
Mr. Jakubiec has his hand up, and also Ms. Wood too. Do you have comments about that?
Oh, okay, Ms. Woods.
So the provision that you're talking about on page 3 of 7, the 2130 020 is talking about the appeal procedures. And I know that first line says an appeal may be filed within 30 days of the decision. And I know that you are talking about, well, how do you get notice of that decision, right? But there is a provision in the code, 2110-020E, that talks about notice of decisions by the planning director. And it says it's 2110-020E, that notice of any decision on an application by the planning and zoning director or the decision-making body must be given to the applicant, the mayor, and the city council, and any other persons who made written comments or testified at a hearing concerning the application, provided they included their legal name and valid mailing address or valid email address. Such notice of decision shall be made by mail or email and provided to the director not more than 5 days following the date of final decision. So doesn't that cover what you're?
Well, the language is perfect. So thanks for, maybe we can just pick up that language. But the problem is in some of these cases, there is no hearing. The director's making this decision on his own.
It just says notice of decision. This is just the director's decision. It's not talking about well, it says person who made written comments or testified at a hearing. There may
Right.
not have been a hearing, you're right, but it gives for both. Any other persons who made written comments or testified at a hearing. It doesn't require that there have been a hearing, but it does cover the language. I think the language wouldn't necessarily belong in the appeal procedures here at 21. Oh, I'm echoing. 2130.020. You're more talking about the decision. How do people get notice of the decision by the director, I think.
In order to do their appeal, to make their appeal in a timely way. And I think all that language you just said kind of covers what Alex was saying, which is, let's make, the burden is going to be on the appellant or the person that's appealing the director's position to do so, not in just an email or casual conversation. They need to put something in writing and send it in. And in that case, then the director will say, yeah, we made our decision. Here's what it is. And they'll post it on eTrecket too. But in this case, there'll be wording that kind of narrows down and puts the burden on the appellant or potential appellant in this case.
No, it doesn't. Doesn't put the burden on the appellant, it puts the burden on the director.
No, I mean, somebody really cares about this. They have to be proactive and be writing to the director saying, we know this is a decision that you're going to be, it's going to be in your hands and you're going to make it. So we want to be notified when you do make it. So we know what to do, or we have the option of doing something.
It's not the applicant. The burden's not on the applicant. It's the director who has to provide the notice to those interested persons.
And
okay, so
only after
the question I want to pose is, given that language that exists elsewhere in the code, thank you, Ms. Wood, is this finding necessary?
I view that as a legal question. And I would, sorry, I know that's, but I'd want to get some legal advice on whether or not that would be necessary if we're talking the same thing there.
I think it's
Which might
covered.
say no, it's covered.
It's covered.
Word to me, but
Covered.
Yeah. Well, does Mr. Kubiak have anything to say about that?
Yep, see his hand.
Well, to be brief, it's covered. It's in there.
Okay.
And the issues that Commissioner Butler are bringing up are relevant, but they're relevant to what is appealable, what decisions does the director make? And I think that's a topic for just a different night and a broader discussion that a planning commission or the Board of Appeals or all of us might have at some point. Because that begins to introduce a lot of complexity into these code provisions. And we're being requested to look at something pretty discrete here. This opens a whole new line of questioning and detailing. And we're not prepared to advise you on that tonight on that particular matter anyway.
But you're living with this code provision as is, right?
Yes.
Okay.
And it's very, right now it's been a huge conflict and there's a big battle going on, if I understand correctly. I don't even know the details, but it's a big problem right now. So I was thinking this might be the opportunity to clarify it.
I have a different view on that, Mr. Chairman, but I don't want to take your time up. I don't see that. I think there's so much public engagement into our local decision-making processes. And while one particular appeal may question that, I'd love for the opportunity to take you through what the staff actually does and how we manage the public involvement process, how we let everyone know of decisions being made and are in compliance with the code. So.
It may have changed quite a bit. So I appreciate that, Mr. Jakubiak, because I think it probably has changed quite a bit since you've been here, and that's good news. So yeah, if Ms. Woods would just give me that code section with the language again, I'll just incorporate it into the findings.
Sure. It's 21-10-020E.
Okay.
And I think some of the, I don't mean to have my hand up. I think some of the controversy you're talking about also involves those minor modifications where the director doesn't have to, put a decision out, and that's really causing some problems. So that's where we're having, I know right now, some controversy.
I want to ask the commission, there's on the floor is a proposed finding number 3. Are we ready for a vote on this?
I am. I mean, I this is what we just got from council saying that it's covered, right?
Yes.
So yeah, I mean, I'm ready for a vote.
Okay. All right. All in favor of the finding, as far as I understand it, is that simply says restates what's already in the code, but that people who have communicated in writing to the director of P&Z or Public Works must be notified of the director's decisions. Okay? Okay, that's the proposed finding.
Yep.
Is there a second to that?
Yeah, I'll second it.
No, wait a minute. Ms. Butler, you made the motion.
Oh, you were making it.
No, I'm not making it. You made the motion. I'm helping you by clarifying the language.
Okay.
Okay. Is there a second?
I'll second it.
All right. Any further discussion on this? All in favor, I want you to raise your hand and also say aye. Okay.
Aye.
Claims,
Aye.
Klein,
Aye.
all in favor, Bellamy, Riley,
Aye.
Aye.
all right, and here's a nay. I think it already exists. It's done. There's no need to repeat it. Okay, any further findings? Anything else? Okay. So our final vote is whether to, given those findings, but our final vote is whether to recommend to the city council that they approve this legislation. Okay? I move that we
With-
recommend approval. Is there a
With
second?
the additions that we discussed.
Yeah,
Right.
the findings will be
Yep.
part of what we say.
I second.
Okay, all right. Any further discussion? All in favor of that recommendation of approval, say aye.
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 Okay, unanimous, 6. Okay. The next item on the agenda is a report on rezoning, which we move to a whole new set of characters who have been waiting in the wings. This is now the third act. This is where the tragedy, becomes evident.
Well,
Lashinsky, you have the floor.
good evening, planning commissioners. Eric Lashinsky, Chief of Comprehensive Planning. If you have any energy left, we have a pretty robust presentation. We may not get through it all tonight. That's fine. I think one thing we've realized is we've moved through our comprehensive rezoning process that we shared with you first back in November with the presentation we gave you then, is that we may have bitten off a bit more than we can actually get done by June, which is what we described as the first phase of our rezoning initiative. And that's really the cutoff that we understand City Council makes to approve zoning legislation prior to an upcoming election, which is next November. So let me go ahead and share my screen. I do want to acknowledge, in addition to our director here, Casey Ortiz is here, who's put a lot of work into the presentation, and our new senior comprehensive planner, Alexis Robinson, is also here. She just started 2 weeks ago, so she's really just more listening in on this, but she'll be very engaged on this once she's up to speed. Let me go ahead and get this shared. So I know, Mr. Bellamy, you were not here when we presented. There may have been a few other commissioners that weren't present, but we have the presentation from November available on the city's website. I can share it later. I'm going to go through a few slides to kind of review what we talked about at that time. But this is the essential agenda, and I think you're welcome to ask questions along the way. If it seems like things are getting kind of into a protracted discussion, I'll probably just try to keep the presentation moving. But we do want to go at a pretty at a slow pace here to make sure you all are understanding what we're suggesting. So I definitely do not want to rush through anything. Right. So comprehensive rezoning. If anybody on the commission or at home that's watching is interested in understanding where this is discussed in our city's code of ordinances, this is the location. It's in chapter 21. There's a section called 21.34 zoning map amendments, which talks about changes to the city's zoning map. And one of the three types of zoning map amendments is called comprehensive zoning map amendment. And this is essentially what we're doing here. I'm not going to go into great detail on that, but just wanted to be transparent about where this is outlined in our process is kind of identified in the city's code. So this is what we laid out in November, this kind of three-phase approach to comprehensive rezoning. By comprehensive rezoning, I do want to make clear that this does not mean that we are rezoning every property in the city. To the contrary, we are being very strategic and specific about rezoning specific discrete places in the city that could have a measurable impact on addressing the goals of the comprehensive plan. And frankly, we want to do this in places where we have support and interest and some consensus. So this is what we talked about. This phase one is what we're going to share a bit more of tonight, and talks about kind of ways that we can address simplifying our very complicated zoning map. This is the schedule we outlined in November. It just hasn't really changed. For the phase one, we're here talking about the recommended zoning map, text changes. We're planning some public workshops in February. No dates set yet, but they'll be in person and virtual. And we really, we should adjust this May date for City Council to really be April, realistically, for them to get any kind of legislation. And that might not be realistic by June. I think any kind of consensus would need to be formed before May. So we'll have to see if we can get to something reasonable. But we've started a website. Casey Ortiz has done a lot of work on this. It's going to grow, and we'll keep adding information to it. There's a very unmemorable website address, annapolis.gov/2236. But I think if you Google Annapolis comprehensive rezoning, it should take you right to this page. On the right sidebar, we'll be putting the presentations like this one tonight and kind of adding to it. So this is where the public can find information about what we're doing with this. This is the basic definition of comprehensive rezoning that we want to convey. It's consistency between the comprehensive plan, the zoning map, and the zoning code. And we talk about the comprehensive plan. We passed it. Thank you. Planning Commission and City Council adopted this in July, and it's called Annapolis Ed 2040, as most of you know. In that, we identified a variety of priorities. Some of them are bulleted here, from pages 38 and 39, and these are the kinds of priorities that we can address through how we develop the city and the kind of guidelines we provide. And we really want to address these. And not all of the plan priorities can be easily addressed through development practices, but all of these can be. And so I just wanted to highlight these priorities that will kind of all be underscored tonight in what I share, either directly or indirectly. The future land use map is kind of that key exhibit in the comprehensive plan that tries to distill those priorities. Still may not be very intuitive to a lot of people, but if you kind of look at what we're talking about here, we're basically dividing up the city into highest and best use of every property in the city. And residential is in yellow. We don't really distinguish what kind of residential development those areas are. Most of them are residential today in some form. The big changes are the amount of green that you see on this map. Most of that was not present in the last comprehensive plan's future land use map. It was sort of buried under other land uses. So what we're doing is highlighting all of these green spaces that already exist in the city, most of which will never be developed, and kind of add value to adjacent parcels. And you can kind of see some of the connections that can be formed when you link these spaces together. And then we're talking about these green spaces in two ways: the parks and open spaces, and then the conservation network. And conservation areas are called environmental enhancement areas, and the parks for recreation are called recreation enhancement. Those are the dark green. And then the red areas are all the mixed use. And I'll talk about more of those layers later. All of what you see in that future land use map, we want to be more consistent with our zoning map, which is this thing here, which kind of disfigures the city, fragments it into all these smaller parcels. We have 31 different zoning districts, which is a lot for an 8 square mile city. Cities many times larger than Annapolis have half of these number of zoning districts. So what we've done is balkanized the city over time into smaller and smaller units that have very, very specific intents for development outcomes, many of which are either not working or redundant. So that's kind of a theme for tonight. If you kind of look at all of those 31 different zoning districts, it's like the periodic table, but maybe even less intuitive or clear. You have some sense of logic here in terms of the B zones being business or commercial uses, the R zones are residential, the P zones are professional office. But then you kind of break up these zones into very minute distinctions that are not very intuitive. And that's really been the kind of trend that we've seen over time since our first zoning code in the 50s. So one thing you do not see in our existing 31 different zoning districts, surprisingly, is a zone that's dedicated to parks and open space or green space in general. And so that's the first thing I want to share. We're proposing one new zoning district that doesn't really exist in any form today. And it would be a parks and open space district. And, a lot of places already have something like this. It sort of makes sense. If you look at the future land use map on the left, where we talk about the environmental enhancement areas and the recreational enhancement areas, there's a lot of opportunities for zoning locations in the future. But the map on the right shows our existing park network and many of our existing conservation easements. This is based on data that we have available. We know that this doesn't include all of the conservation areas that exist, but what we want to do is put all of the dedicated parkland and all of the conservation easements that do exist into this zone, give it some definition, and use this zone in the future for other areas that are conserved or dedicated as parkland. We will not be putting Anne Arundel County Public Schools in this, although our future land use map does identify some of their properties as recreational enhancement areas. But we want to be clear that their properties are somewhat independent of this. And if they want to zone them that way, it's their prerogative. But that's the only new zoning district that we're proposing that really doesn't exist today. The bulk of the presentation is what we're calling zoning district consolidation. It basically means trying to simplify the number of zoning districts we have in a way that gets us to fewer zones tomorrow. Looking again at the future land use map on the left from the comprehensive plan, if you pull out just those areas that we identified as great opportunities for mixed use, meaning combining multiple land uses that are compatible with each other, such as residential and retail that serves the residents living nearby. You can kind of see the pattern here. The mixed use areas are along our major corridors. Forest Drive is right here. West Street is right here. Chinkapin, Old Solomon's Island Road, Bay Ridge Avenue. That's what we're going to be talking about quite a bit tonight. Because when it comes down to it, all of those plan priorities that I shared before from the comprehensive plan, many of them can be addressed by more efficient approach to how we develop the city's limited land base. And one of the big takeaways from the comprehensive plan is simply that if we encourage more mixed-use development, we can be far more efficient in how we utilize our resources and minimizing costs and distances that people have to travel to get places and how they get around the city, and really situating things that people need closer to where they live, work, go to school. And so that's why we're talking about mixed use a lot in this presentation. If you look on those corridors where we've identified opportunities for mixed use in the future, you can see a number of zoning districts that are either inconsistent, where the uses on those parcels today are inconsistent with the comprehensive plan's future land use vision. They're either they might be redundant or outdated or underutilized zoning districts, or they might be places where the community nearby has actually advocated for change, which happened during our comprehensive planning process. So when you take all of those criteria together, we've identified nine zones that we think could get us a more simple zoning map, or at least start to make for a more simple zoning map. And these are the zones. I'm going to talk about them, kind of going neighborhood by neighborhood. But first, I want to say that part of this is also about elevating a couple of zones that we already have that we think could be better serving the city. And that's the MX zone, which stands for mixed use, and the BCE, which stands for business corridor enhancement. These are both relatively new zones in terms of city's zoning history. The MX was something that was developed in the late 1990s, the BCE in the early 2000s. And you can see where they're located. MX, Inner West Street in green here. The BCE is Upper West Street and a little pocket off of Hudson Street as well, in Chinkapin. So you can also see, they're solidly located in these places where we've already identified opportunities for mixed use. How these compare? Well, they're kind of different levels of density and intensity, where the MX is, I would say, focusing on a more granular streetscape. That you can identify with Inner West Street, smaller footprint developments, and then the BCE is aimed at larger parcels of land that could be more intense in terms of the number of uses on the particular property and more dense. This is the 1901 West Street property at the corner of Chinkopin and West Street. Not every property might be looking like this, but these are just two representative examples from these two existing zoning districts. And here's some other examples from those zoning districts. And it's really important to acknowledge that at this point in the present, we have a lot of buildings and uses in the city that predate our zoning. So in some sense, the zoning that we have today is not necessarily always going to be indicative of what you could get in terms of a development outcome, but we can be far more proactive and deliberate in how we structure our zoning requirements and create our zoning map to get better outcomes and really address the goals of the comp plan. One thing we're going to do is
Eric.
Yep.
Sorry to interrupt you, but
Yep.
in terms of the those who predated some of our zoning, is there a are they grandfathered in? Is there some rule that we can't enforce or we can't otherwise have purview over them?
Well, they're allowed to be non-conforming, which means that they don't necessarily meet the intents of their zoning district. But when the property turns over, and they're allowed to continue being non-conforming as long as there's continuous use of the property. So you see quite a few examples of that in the city. Once that property becomes vacant for more than a year, it loses that ability to be non-conforming, and the new use that comes in has to be an allowed use in that zoning district. So that's kind of how that works. There's definitely plenty of properties in the city that have just been continuing with uses that may not be allowed in their zoning district today. But one of the things I think distinguishes the MX and the BC, and why we talk about these as maybe good things to promote from a mixed use perspective, you look at the kind of uses that are allowed. In yellow on the left side are typical residential uses, how our zoning use tables define them. Multifamily is just kind of an apartment building, and then in orange are just a sampling of the kinds of retail establishments that you might want to have in a mixed use to really be compatible with the residential nearby. And you can see most of these are really, P means they're permitted by right. S means they're permitted by a special exception. STD means they're allowed but subject to standards. And then where there's dash, it means they're not allowed at all. And so you can see that the main difference here is that the BCE is not really encouraging the single family, smaller residential options. It's really aiming for higher density mixed use, higher density multifamily type residential, if it has any residential at all. And whereas the MX really could include a whole variety of housing types. So those are the main differences. The other distinction, which we don't have any slides that really get into, we're still working on graphics that can speak to the height and bulk differences between our zoning categories, which I think next time we meet with you, we'll have something to share on that, particularly in relation to MX and BCE. But just offhand, I can say that, generally with the mixed use, you'll be able to go up to like 3 stories. And with BC, you could go up to maybe 4 stories. That's that's kind of, I mean, the density can get higher in the BCE in terms of the number of units. But I think we're working on some graphics that kind of help show on, typical sites or not typical sites, what you might be able to get if you change the zoning. Because we know that's a major concern of folks. And we want to be clear about what the anticipated bulk of a new development might be. Let's see. So then, if you compare MX and BCE to a whole range of other zones that we think are appropriate to be eliminated, you can kind of see some of these either don't allow for a range of residential types that we want to include. In the case of the B3CD, the BR, I'll go into the detail what some of these other districts mean, but you can kind of see that some do allow quite a few of the different residential types, some don't. And then when you get into the commercial categories of things that we talk about wanting in mixed use areas, you can see it gets much more scattered. The things, this District P, which is professional office, well, it was pretty permissive when it came to residential options. When you get into retail, it's not really very permissive, and you can't even have a coffee shop or a convenience store or a deli, and so we're looking at these zoning districts where you can really have a synergy of uses that makes sense and give property owners some flexibility as the economy changes and the office uses are not as viable. They can have other sensible uses come in and really activate a site in a way that works. So that's kind of what we're thinking with this. So now I'm going to start going into neighborhood focused areas, and this we're going to really get into some of the details and in the places where we've identified opportunities to change zoning districts. First one, and I should have said I can't see anybody, so just interrupt me if you have a question. West Annapolis is an area that has been advocating for zoning change for some time. During the comprehensive planning process, we even did a master plan for the commercial area of West Annapolis and talk through a lot of zoning change ideas and kind of vision that nearby residents had for the area. This is the current zoning. And I should be clear, this is going to be the case with all of the neighborhood focus areas where we're only looking at certain zoning types, certain zoning districts. Again, these are the ones that we think make sense to eliminate from the zoning map. So in this case, P and PM, we have the Navy Stadium right here for orientation, Taylor Avenue, Rao Boulevard, the Archives building is right here. Looking at P first, this professional office district, this shows up throughout the city in a bunch of locations. They're all numbered here. Just for context, we're still only going to be looking at the West Annapolis portion, but just to put this in perspective, this is essentially an office type use that is intended. And so when you look at those P zones in West Annapolis, these are kind of building types that you see. We don't expect some of these buildings to turn over very soon at all, particularly the Archives building or this nearly new office building on the top. But this just gives you a sense of what has worked in the P district so far. And then professional mixed office, this PM zone, this is also something that shows up in various parts of the city, primarily along West Street corridor. But in West Annapolis, it shows up in building types like this. And again, some of these may have preceded the current zoning designation. I think particularly this building at the corner of Annapolis Street and Taylor, I think probably preceded this PM district. There are buildings within the P and PM zone that could be retrofitted relatively easily to achieve the kind of mixed use goals that we're talking about. This is a medical office building on Giddings that has essentially street level retail, but it's more institutional, related to medical services. So it's not as if every building would need to be rebuilt or reconstructed, every site to achieve these goals. I mean, some of these, with more flexibility in the zoning, could have uses that could just come in and adapt the building to be to catalyze new opportunities. And really, some of these buildings are already addressing some, in terms of walkability and street activity. But if we do want to see new development in certain places, I mean, this is kind of what we're talking about in terms of sort of mixed use in the West Annapolis area. I mean, this image on the right is a newer building that we've highlighted before on Annapolis Street. It's a good example of how mixed use can blend in with the existing context. It really does that well. And then a couple other examples, different types of mixed use that exist in Annapolis today. Bottom is Maryland Avenue, and the top left is West Street, Inner West Street. And so when we look at the P and the PM, you can see the PM achieves a lot of what we're looking for, but not everything. And it's just frankly redundant with the MX district, in some case the BCE. The P district also doesn't really achieve most of what we'd be looking for in MX area. And so that's partly why we have it. These are office districts. They privilege office uses. It's not to say you couldn't have office uses in the MX or BCE. Those already exist in those parts of the city where we have that zoning. So we're simply trying to consolidate here and do more with fewer zones. And so based on that, this is what we're looking at proposing presently. I mean, all of what we're going to share tonight is very draft preliminary suggestions. We're going to be studying these more, and I think there's more information that we need to provide to show the kind of development outcomes that could happen in these locations. But this is what we're showing you here, is that the parcels closest to Raoul Boulevard would change from P or PM to BCE, which again stands for Business Corridor Enhancement. It's ideal for locations on higher volume roadways, where more traffic happens. These are areas that are farther from residential areas. And then the MX is best intended for areas closer to residential, where you want a smaller, finer grain of mixed use development, the kind that you've seen on Inner West Street. And then there's a couple of places where we're recommending this open space, parks and open space zoning. On the left, this is just kind of a marginal piece of real estate along Raoul Boulevard that won't ever be developed. It's just a green area today with trees. So it just makes sense. And then this portion on the right is where the city is working to develop the Gateway Park concept, which is essentially a passive nature park. So that would only see trails, trailhead, some minimal parking improvements, nothing major, but identifying that as a park use would make sense. So that's what we're looking at for West Annapolis. Everybody still with me? Any questions?
Why the B1?
We-
Why is that not potentially mixed?
Yeah, that's a great question. We've been agonizing over that. The B1 and the B2, both of those, are really, I think they're candidates for mixed use zoning. They allow it today to some degree, just not enough. They show up all over the city, particularly the B2. And I think in realizing that a practical level, these sites are going to be, if the supermarket site where the Growls is today it's B2, where if that were to be developed, it would be a planned development. It would be able to take advantage of the flexibility that come with planned development guidelines in the city. We felt that it might open up a whole nother set of discussion to try to eliminate the B1 or the B2. The zones we're focusing on to transition are, I guess you could call them like the lower hanging fruit, the ones that are just kind of too specific. So that was sort of the thinking. They are candidates for rezoning. I think that's probably that'll happen in the next phase, perhaps, of our process, but we just saw them as a bigger lift to kind of make the case.
Can you, Eric, I'm sorry, just really briefly, could you just kind of summarize the difference of B1, B2 for me?
Yeah. So B1 is, I think it's a community shopping district. It's, Annapolis Street is B1. Really, there's two locations in the city that are B1. It's Annapolis Street here in West Annapolis, and then the stretch of Bay Ridge Avenue in Eastport, where VIN 909 is located, and has a lot of kind of not a lot of retail today, but historically was kind of a smaller scale retail corridor. And then the B2 is what's called convenience shopping district, I believe it stands for, and it's larger shopping center sites primarily is where you'll see that zoning show up. So, I can't really get into all the nuances of exactly what differentiates them in terms of the uses they allow and their kind of height and bulk limits. So, but generally the B1 is finer grain commercial neighborhood scale, and then the B2 are kind of larger parking lot type shopping centers. So that's kind of what we're talking about. But yeah, so
Eric, just to put a finer point on the B2 piece here with the Grauls Plaza on it. So what you're really talking about is switching all zones throughout the city from one to another versus it might, in this particular case, might make sense that particular B2 set of parcels would be better off as BCE, but that requires changing the zoning for those specific parcels that is a heavier lift.
Yeah.
That's the idea, basically.
It wouldn't be outside of, it would not be a crazy thing to make that change here in this location. I think it would be an anomaly to our process, in a sense that this would be a location where we're sort of keeping the B2 everywhere else, but changing it here. So we just felt for simplicity's sake, it might make sense just to not touch it. Just trying to, it's a slippery slope. I mean, we certainly want to make changes that will lead to better development outcomes. And this is, I think, a recommendation that came up in the comp plan process is to look at rezoning this shopping center site where the Growls is, but we just figured we wanted to steer clear of that at this point. But
yeah, I mean, I suppose unless the property owners wanted that, but It's a heavier lift, yeah, for sure.
Even as a planned development, don't you have to abide by certain underlying zoning rules?
You do have to, you can only have the uses that are allowed in your underlying zoning. You are allowed to bump up the residential density to R4, but yeah, the other types of uses that you could have there have to be already allowed within the B2 zoning district.
I don't understand the hesitation.
No, it's a fair comment. I mean, I think that's the kind of input we're looking for. Because we definitely,
And the other pink, the B1, is like I same thing. It's like, why are you not looking for the MX level of activity there? Something. I mean, all of that work that was done in terms of what should be done with West Annapolis, it looks like it's like some of it's being ignored.
These are good comments. I think, it's particularly if we see that getting to any kind of resolution on recommendation for city council is not realistic by June, that gives us a larger window to, if you all think that doing this the right way involves looking at sites like this, then I think that's where, that's the kind of guidance we're looking for, I think.
And Eric, I can add that we began this process with looking at consolidating districts that seem to go well together and not making the specific recommendations about upzoning or changing zones in particular at this moment. But we actually encountered the same discussions you're having in our last series of meetings about what to do when these situations come up. And it's not our intent to ignore that or to suggest that B2 is not the right zone or is the right zone, but we kind of wanted to go through the process of dealing with the lot or the zone consolidations first at that sort of policy level, then dig a little deeper about the zoning changes, particularly with B1 and B2 throughout the city. Because there are a number of locations throughout the city where a mixed use approach is advisable and would be consistent with the comp plan. But we just thought we'd stay on the track of dealing with consolidations at this moment.
Yeah.
If the other districts, the other B1 and 2 districts across the city lend themselves to a long-term MX, why not?
Well, we don't know yet. They may very well, they may not. We just haven't made that judgment.
Okay.
It needs more study.
Yeah.
I don't. Okay.
This line of discussion will probably come up as we get into other parts of the city. But yeah, I mean, this is the end of the West Annapolis section here. We can go back to anything that comes up. Let's see. Oops. Sorry. Okay. Kind of moving into the downtown Annapolis area, I want to be clear, just as we did with West Annapolis, we're being very targeted in the locations we're looking at rezoning, consolidating the zoning for downtown Annapolis. This is very limited to these sites that you can see here. We have some portions of the P zoning, and then we have this zoning district called the C2A, which I'm going to get into. In the P, you can kind of see if, it includes a lot of state office buildings, the circuit court, governor's mansion, the state house. So those are the kind. And then Acton Cove is down the south end, the new residential infill that happened after the city's hospital relocated to the outside of the city. So that's just some context. The C2A are some very specific sites that we have some images for. But obviously, the important concern when looking at anywhere in downtown is where is the historic district. That guides so much of what happens in the downtown area. It sort of supersedes a lot of our zoning guidelines in terms of regulations governing facade improvements and additions, and the way in which a building could be changed over time. So you can see the red line is the historic district. You can see the range of zoning districts that already exist within the historic district. I think it's important to acknowledge that obviously a lot of our most historic buildings have been adapted successfully over time. I think it's a major success. Sometimes it's a testament to those buildings and their ability to be flexible as the culture changes and population changes and needs change. At some point, we created this district called the C2A, the Special Conservation Business District. I don't know which of these properties first triggered this idea, but it's a very specific kind of district. It's basically sites where you have a commercial location surrounded by residential, or where you're transitioning from a commercial corridor like Main Street to a residential side street. You can see the kinds of the 4 locations where this exists today. You have the former flower shop on King George and College Avenue. You have a strip of really, I would say, successful mixed use on Maryland Avenue, where the old Fox bookstore is located. You have this interesting building at the intersection of Fleet and Cornhill Streets. That is also a pretty interesting mixed-use building. And then right around the corner from Hats in the Belfry is this stately building that really feels pretty removed from Main Street, but it's kind of in this C2A zoning district, and it's kind of been limiting what can happen in that building. And so when you look at C2A in comparison to C2, which is more of a all-encompassing conservation commercial district that it includes Main Street and most of Maryland Avenue, you can see the kind of uses that are allowed in the C2 but not in the C2A, both for residential and for commercial uses. That's kind of the thinking here. The C2A in these 4 cases would make sense to convert to the C2 to consolidate. And then where we have the P district, again, this is a district that you find across the city in the downtown area, state buildings, the Acton Cove redevelopment, which has been very successful. And then you have some medical office buildings, formerly medical office, that were converted into condos. And that's been a trend in a few cases. So these are the kind of places that exist in the P district of downtown today. And if you compare the uses from the P to the C1 to the C2, what we're looking at here are likely candidates to replace the P. And, it's the C1 is the district that encompasses most of the residential areas of the historic district. The R4 is a district that the Acton Cove redevelopment would fit into if it was anywhere else in the city. And then the C2 is more of that commercial zoning, but also extremely successful as a mixed use if you look at Main Street and Maryland Avenue. So based on that analysis, this is what we came to. We are proposing in the area north of Cathedral Street, the P zone there, we're talking about changing that from P to C2. Conservation Commercial District. South of Cathedral, where the Acton Cove development, infill development is, we would go from P to C1, which is this Conservation Residential District. There's an I shouldn't call it odd. There's an outlier site at the corner of Shaw and Citygate Lane that is P today. We would be transitioning that to the R4, which is our highest density residential zoning district, but appropriate for that location. And then all those C2A, those 4 sites would become C2. I should have started with that, going by the list on the left here, but all 4 of those C2A locations are essentially sites that could be successful mixed use. Flower shop, probably more limited. It probably is going to be one use only, but the rest of them could accommodate mixed uses. So this is the last slide for the downtown section. I should say every time we complete a neighborhood area, the lower left image shows the existing zoning today, and then the larger image is the proposed zoning. And I know this one is a little bit complicated. There's a lot of other background zoning we're showing, like the green is the existing MX zone. We're only talking about the sites that have a large zoning acronym on top of them, where we have R4, C1, C2, and then so.
And I want to add a note on top of what Eric said about that R4 site. It would have been C1 like the other site, but because it's outside the historic district, that's what led us to that site going from P to R4, was only because it's outside the historic district.
Yeah, that's a good distinction.
Eric, it's 9:45.
Yep.
We've got a few things to do at the end, so.
This might be a good stopping point. I can give you a teaser.
Go.
But in terms of the other neighborhood focus areas, we should have had a key map in the beginning. But we talk about the old 4th Ward and President's Hill in this area off of West Street. We get into Germantown, Homewood, in a set of slides here. We get into the Parole area. Let's see. The Parole area here. And again, in each case, we're being very selective and generally looking at only these zoning types that we identify at the beginning that are opportunities for consolidation. And then finally, there's a group of scattered sites, some on Forest Drive, and then some kind of in the Eastport area, just smaller sites. But and I think stopping where we were, it makes good sense. I think it's a lot. So
what this also means is that the only changes you'll make between now and June, okay, that you're proposing to the council is the compression or the change of these few zoning districts. Okay. You're not talking about changing any areas, that we've focused on, like West Annapolis, like the Annapolis Seafood on Forest Drive. You've not looked at any of those low-hanging fruit that could be turned into MX or whatever. So you're not proposing any specific changes. I mean, the problem is that at the Annapolis Seafood, it may be a Wawa by the time you get around to rezoning it to something higher.
Well, I should have said this at the beginning, and one of the things we're also doing right now, and we don't have anything to share tonight on it, and it's kind of moving on a parallel path, is looking at our plan development guidelines, and how we could both clarify and have more specific requirements associated with the plan development projects, how they could better address the streetscape area around them and create, higher quality development. So, I mean, that's something that we're working on separately, and it would guide those major infills. I mean, it's a good point that you bring up. I mean, we did identify these major infill sites in the comprehensive plan, and we are mostly steering clear of those in what we're sharing with you at this point. But the plan development guidelines in the city's code would address all of those sites, and that's where I think we could probably be more effective, frankly. Is that's really the mechanism that these developers will be using for those sites. So,
can I just ask a question here? I mean, this is a big, a fairly significant consolidation of our zoning into. I mean, you're basically you're doing away with 65% of our zoning codes, which I think is the right thing to do in an 8 square mile radius, right? I mean, we're taking 31 down to 9 or 10. Is that?
No.
Oh.
We're actually, it's not that substantial. I mean, I think we want to get to a lower number, but right now we'd only be reducing 31.
25.
Yeah, to
31 to 25. Okay.
Yeah.
Maybe that's my dream. Maybe I'm just like ahead of myself here in terms of where I think we ultimately need to be, because we're just way too small to have so many different ones. So I haven't had a chance to wrap my head around even just what you presented. I don't think that we should use what is not any more time that we have available tonight to try to walk through what you presented. I think we have enough information I have enough information to kind of walk through it and reach back out and ask specific questions, and then really consider the different parts of the city, because I think we have a very unique city, and each one of those buildings has kind of a unique use case. And then you've got some of this grandfathered in. It's pretty complicated. Your job is very complex, and what you're asking us to consider obviously has a lot of complexities. The question I was going to ask was, is this like a first phase, or do you think that this is like part of the comprehensive plan, or do you think that there's more to come?
This is definitely the first phase. I mean, the way we've been structuring it is that we're looking at, this is a little bit like the low-hanging fruit, this first phase, these zones that kind of, redundant, as I said, redundant, outdated, et cetera. Let me go back to the beginning just real quick and just show you like what we talk about for phase 2. Form-based standards for major corridors and mixed use areas. This is where I think we would certainly be looking at those B1 and B2 zones. I mean, those do show up at major intersections all along Forest Drive and Bay Ridge Avenue and West Street, and so that's really where I think we would be getting into finer detail at those sites. The third phase is actually looking at residential areas and the degree to which we could find opportunities for housing options within our existing residential areas. But it's going to be a challenging phase, and really it's going to have to require certain design guidelines as part of it. So it's probably the most involved, I think, but that's the way we're structuring it.
So let me go back though. You say that in the interim, that plan development would be a sufficient tool to work in some of these areas, even without a zoning map change. Did I hear that correctly?
Yeah, that's right.
Okay. but then you have to update the code, okay? And then the next phase involves form-based standards, okay? And shouldn't those form-based standards be integrated into the plan development standards?
I anticipate they would be when we have, it's just a more involved process. I think really I think you could point to some great outcomes that have come through our existing plan development code. But it's really relied on having staff work very closely with developer teams to get those outcomes. I wouldn't say that we've started with expectations well clarified in our code. It's been more through kind of that iterative engagement process with staff and other stakeholders to get to outcomes that everybody likes. So to the degree we would be changing our plan development code, it would be adding detail that would help a potential developer understand expectation better. What is it, what that we're looking for? And you can do that without form-based standards in terms of, like, for example, today our plan development code simply says the project has to be consistent with a comprehensive plan, but we could be much more specific about what that means. What are we actually looking for in terms of our what goals are we trying to reach here? And then that could be a start, but then the form-based standards would go even further. And I think some of the projects that we see coming online could help set that standard. The Annapolis Seafood Market site, particularly. I mean, trying to change the development pattern along Forest Drive and make it less of a highway and more of a walkable boulevard type corridor.
Well, I think that, it's a worthy and necessary task to add more detail of what we expect in a plan development, but it merges into form-based standards in some ways. What kind of sidewalks do we want? What kind of lighting do we want? What kind of recreational areas do we want? How high will we let it go? I mean, those are the things that we need to get installed quickly.
Yeah.
And if you want to play around with form-based stuff later, but this is the beginning of form-based standards. I think that plan development code, it'll be more general than form-based standards, but still, I agree with you. Our goals need to be clearly and much more detailed stated than they are now. Needs to be consistent with the comp plan. Well, that could be anything.
Yeah.
Anything. And right, and you're involved in negotiations with these developers, and they say, well, I'm consistent. No, anyway, but if you say no, every plan development that involves a certain amount of residential has to have recreation, whatever the kinds of things you're thinking of. That's what I want to see next, because we're not going to get form-based stuff for a year. We need to move faster than that, though. Okay?
Yep.
Okay.
Got it.
All right. See you in February.
Good input. Yeah, absolutely. Look forward to hearing when your next date will be.
Yeah. So we want to hear what the plan, your plan development ideas are.
All right.
Because I think Steve's right. It's like the specifics in these specific little areas are really fine grained. It's hard to get, focused on. We might think about how better to do that okay.
Yep. That's great input. Makes sense
for us to talk about these things and keep moving.
Yep.
But in the meantime, plan development.
Yeah.
If that's going to be your toolkit, we need more tools in that kit.
Yeah.
Okay.
Yep.
All right. Mr. Riley, did I expand upon your thoughts?
Yeah, I mean, I'm a bit of a novice when it comes to how we make the political process work and be respectful of all different stakeholders. At the same time, I'm an entrepreneur, and I kind of sometimes push the conversation, if not the actual decision making. But I've been impressed with everything that I've seen so far since I've joined the board. I just think that we have this amazing opportunity to take it's just kind of gotten out of control. It's not that all the decisions that were made to bring in C2A and all these other zoning areas weren't the right decision at the time, but now we have this opportunity to kind of reset that and to simplify things. So I'd rather kind of think about it I'd rather simplify things and make everybody else fit into it than to look at all these individual properties and think about like how we're going to build something around them. So I maybe that's a little naive of me. Eric, I think you're being very respectful of all the different rules and people that are grandfathered in and all those kind of things. But I don't see any reason why we need to have 30 different, kind of zoning considerations when we could have 10. So I like moving this process a little bit more swiftly because it's just the right thing to do. And there is some low hanging fruit. I just don't want to do it to the tune of like, let's go from 31 to 25. Let's go from 25 to 22. Because then we just keep kind of coming back to, instead of just saying, this is the right thing to do. Let's figure out where everybody can fit into it and be as thoughtful and respectful as we can be. So, but again, that's a little of my political naivete and all due respect to present company.
All right.
Gotcha.
All right.
All right.
This group wants to move.
I see that.
Yeah, it's good.
Thanks, Eric.
Sure. It's good to be with you.
All right, again, and Ms. Robinson, we can't wait to meet you.
Yeah. We look forward to seeing you in person.
She's gone.
Your next meeting. Yeah.
All right. All right.
Yeah.
Sounds good.
Thanks, Eric.
Sure.
So we need to move along. There's the two administrative things to do. One is this report that includes everything that we did last year, including our attendance records. It's always revelatory to look at our past behaviors. Nonetheless, we need to, edit it, approve it, amend it, approve it. It's a short document. Send to Google Drive. Any discussion about it? I do recommend that you take just a quick glance at it at some point to see what kinds of things we did do last year and who was here.
I've already made comments in it.
Huh?
I made comments in it quite a while ago.
Oh.
So I'm all set with it.
Yeah, same set. And I made sure the attendance records were accurate for me at least.
Yep.
Oh, you're hard to keep up with, man. All right. Do I hear a motion to approve that report that goes to the city clerk?
So moved.
So moved.
Any second?
Second.
Any discussion? All in favor of submitting it, please say aye.
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 Hi.
Any nays? Good. We have an election of officers for chairman and vice chairman. Why don't we do chairman first? I'm just flipping a coin. Any nominations?
I'll nominate Mr. Waldman.
I would second that nomination.
I'll accept that nomination. Anybody else? Since it's unopposed, let's have an open vote. All in favor, say aye.
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 Thank you very much, my colleagues. I've been trying to treat this commission as a collection of colleagues. And that I think it's beginning to work out. I think we're getting better at moving along and making decisions. And I appreciate the work that you guys do. I mean, I know what it is. Next is vice chair. Do we have any nominations or anybody who would like to run?
I wouldn't mind doing vice chair job.
I'll nominate her. Ms. Butler,
Thank you.
you're welcome.
And I will second Miss Butler.
Mr. Klein, what are you up to?
I mean, if we have a nominee already, that would be. I won't necessarily put my hat in the ring because I have some other commitments this year that are gonna keep me busy. So maybe in future I would step back into vice chair.
Okay.
So.
All right. Anybody else? Since the nominee is unopposed, we can have a public vote. All in favor of Ms. Butler, say aye.
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 Any nays? Okay.
Thank you. I hope to do a good job backing Bob up in these meetings. Appreciate it.
Okay. I hope you do. I can use the help. All right. I would like everybody to just stick around for a minute after we go offline. I will announce what I want to discuss is that Mr. Jakubiec has offered to meet with two of you at a time for just coffee and chat and conversation, and where you can meet each other and ask the kinds of questions you need to ask that are often not appropriate or relevant in a meeting. So let's go offline and that's what we'll discuss as to who wants to meet and when. Okay?